Morning, everybody. Welcome to the Michigan Public Appeals Court Quarterly. Just want to make a little short announcement. Around here today. First, council endorsed council on the first case. For others here today, just a reminder of silence your cell phone, please, and most importantly, we don't allow any audio to be recorded here unless you don't have a problem with you actually behind the one of the sessions, put those down, not help. I believe the council here after the case, I believe Judge Young is going to give 2 minutes. So and the further case is situated now. Thank you. All right. Hear ye, hear ye, hear ye. Court of Appeals of the State of Michigan is now accepted. The Honorable Christina Robinson Garrett, the Honorable Randy J. Wallace, and presiding, the Honorable Adrian N. Young. All persons having business herein draw near, give attention, and they shall be heard. God save these United States, State of Michigan, and this honorable. Thanks.
Hi, everyone. Good morning. My name is Judge Adrian Young. And as you just heard, I'm joined today on the bench by Judge Christina Robinson Garrett and Judge Randy Wallace. As is obvious for folks who are regulars here, we have just a handful more people than usual. And most folks I think are here for our first case that I'm going to call. So the plan right now is to pause for a beat after the first case in the event folks want to leave. If you want to stay, it's a great time. So you are more than welcome to. But I do want to just let you know there is going to be that pause to kind of shuffle out and leave if you want to. I'm going to jump right in. I think at the very end of the call, we have some cases involving minors. I don't think throughout the day we have any other cases where the identities of individuals should be kept private, but just bear that in mind. Everything's streamed on YouTube. This is actually live streamed today. So this is about as public as it gets. So just keep that in mind as you make your arguments, and we'll dive right in, barring anything from my colleagues. So I'll go ahead and call the first case, case number 14, item number 370569, Heart of the Lakes Community versus West Bloomfield School District.
Good morning, Your Honors. Derek Howard on behalf of appellants.
You may proceed.
I don't want to belabor what's in our brief. Our brief is the briefing in this case has been very well done by both sides, but I do want to make some points. If a public body that is subject to the Open Meetings Act can avoid public scrutiny of its decisions by delegating decision-making related to controversial topics, then that has a potential to leave a gaping hole in the Open Meetings Act. The trial court left a gaping hole in the Open Meetings Act. Trial court did so by making repeated references to recommendations. There were not recommendations. There was a recommendation: knock down Roosevelt. That was the only recommendation. Demolition was the only option considered publicly, even though there were 5 others that were considered non-publicly. The trial court specifically found, but did not appear to appreciate, that the decision to demolish Roosevelt was done before the September vote at which the vote was taken. That's the trial court order exhibit 1 at page 25. The trial court claimed deliberation at the July 17th, 2023 meeting happened. That is not true. That is exhibit 9 to our brief. It is a single line item. It says in that exhibit, Superintendent Bozzi, Mr. Long, and Mr. Stottlemyre gave an overview of the recommendation prepared by the West Bloomfield School District Strategic Vision Committee. The Strategic Vision Committee was delegated authority to consider and narrow options to a single option that was rubber stamped. It goes on in item 6, the committee reviewed and analyzed the following elements during the process, and it says some. The next page, item number 4, the old Roosevelt building will be demolished and converted into multi-use fields. That was the only option. It was the only option because other options were considered privately in a non-public setting. We FOIA'd some documents. We got a couple of documents. Exhibit 10 is one. It's a Strategic Vision Committee. It acknowledges that privately they considered 5 options. It doesn't say even what those options were. We still to this day have no idea what the other options were. The trial court and appellee repeatedly refer to public posting. In making its decision to deny the preliminary injunction, the trial court admitted that it looked at the website and it did not watch the videos. That's appellee exhibit C at lines 18, or on page 10, lines 18 through 24. The court at the TRO hearing said it was going to look at the videos. That was important evidence. It admitted at the preliminary injunction hearing that when it denied the preliminary injunction, it did not do so. It didn't do so on the record before it. But even if they were, let's say the options were, public posting is not public deliberation. At best, public posting is, here are the options that we considered in private, but not the reasons behind the decision, not the deliberation that's required under the Act and under Booth newspapers. And the West Bloomfield School District publicly represented at the September 18th hearing that the question of demolition could be revisited. That's appellee Nelson Hirsch, who told the public, quote, one of the bones of contention is demolishing Roosevelt. You know, cut to the chase. It's going to take 9 months or more to take down Roosevelt. This gives us a deadline to find a repurpose for Roosevelt. It's going to take 9 months or so. So I support the recommendation to knock down Roosevelt because I know we can all hope. We can see what comes up. Member Halsworth said the same thing. I'm voting no, but with a comment that the things that Carol Finkelstein, who decried the lack of fiscal responsibility, asking for are sort of things that would need to be included in a solid proposal. Dr. Bazzi has already said they will, as a board, provide us with any viable redevelopment options. In other words, the option to redevelop Roosevelt was on the table. I think it was a controversial topic at that hearing, and so they wanted to placate a very loud public, you see them, a very loud public about hold on, we're going to revisit this. You can't make the promise to revisit something after the September 18th meeting to the public in order to encourage them not to act under their act. And then later on say, but the decision was made back then. You can't have it both ways. It's inconsistent. Stacy Brinkman, same thing, reaffirmed. It's all in our brief. While it is understandable, if you read the trial court's opinion, what I'm taken by is the trial court seemed to want to protect elected officials. And I get that. The trial court's an elected official. It's understandable that elected trial court judge would want to presume elected officials are acting fairly and being transparent. Our founding father, James Madison, famously warned, quote, all men having power ought to be mistrusted, and only the maximum of free government ought to be that trust no man living with power to endanger the public liberty. The trial court's ruling turns this foundational principle of the United States government on its head and approaches the legal question of appellee's intent and if they should be presumed trustworthy rather than be presumed self-interested, a dangerous precedent. Do we want to just trust blindly what our elected officials are doing these days? Or do we want the public who has a right under the Open Meetings Act to be able to question those decisions? In all meaningful ways, this case is directly on point with Booth newspapers. It's directly on point with Pine Brook Warren, a Michigan Supreme Court for publication decision in which they found that a review committee was subject to the Open Meetings Act. This case is directly on point with a case that came out of the Court of Appeals for publication after all briefing was concluded in this matter. Exclusive Capital Partners, LLC v. City of Royal Oak, decided December 4th, 2024, dockets number 366247 and 366257. In that case, a city commission was tasked with approving marijuana licenses, and it delegated that authority to the city manager, who with the help of a work group narrowed 31 license applicants down to 2. This court held in a published decision that's not on square with Booth newspapers. That's not on square with Pine Brook. That is the city manager, by narrowing options and recommending, all I did was recommend 2. The city just rubber stamped those 2. That was a violation of the Open Meetings Act. One cannot read Booth newspapers, Pine Brook Warren, in exclusive capital partners, and conclude that the West Bloomfield School District did not violate the Open Meetings Act. You can't do it. The focus of the Open Meetings Act under Booth newspapers is opening the political process to public scrutiny. West Bloomfield School District's story has changed repeatedly. Roosevelt is too expensive to maintain. Roosevelt is damaged and had to be knocked down. Now the switch latest in the media, Roosevelt, a bunch of billionaires just want to get Roosevelt. This case in meaningful ways is like Booth newspapers and Pine Brook Warren and exclusive capital partners. But it's different in one meaningful way. The plaintiff in Booth newspapers was a media organization. The plaintiff in Pine Brook Warren was a business. The plaintiff in exclusive capital partners was a business. This is the public. They don't make money if Roosevelt is saved. They don't have billions of dollars. They do grassroots fundraising to save the school. Who is the Open Meetings Act supposed to protect? They are doing everything they can. They want answers. These are their elected officials. They're the ones that are selling T-shirts and doing events to raise money to pursue this. They're the ones that elected these officials and want to know what happened. They deserve to know why. I'll answer any questions you have.
Council, I have one question. So in your amended and updated emergency motion for a TRO, you argue that the defendants violated the Open Meetings Act with respect to the bids received for demolition and asbestos abatement, which the board voted on at the March 18th, 2024 meeting. Should the focus of this appeal in light of that be on the March 18th, 2024 meeting and the bids?
That's one of the focuses, Judge. I think with respect to the March 18th meeting, our count 3 alleges that the West Bloomfield School District has an ongoing pattern of violating the Open Meetings Act, and therefore we deserve a preliminary injunction and an order saying stop doing it and redo everything. With respect to those bids, that in particular piece is what the trial court had relied on for saying you posted the bids on a public site. In other words, ultimately what happened was there were 3 asbestos abatement bids and there were 10 bids for demolition. Of the 3 asbestos abatement bids, they selected the one that was multiple times lower than every other bid, and they didn't describe why. They never talked about it. When she talks in her opinion on page 25 about the bids were posted on the public site, again, posting the bids is not that it didn't happen. We have evidence of that, and we attached it as Exhibit A. But if it did, just putting up what options were considered behind closed doors is not the same thing as delivering on those options. These are the folks that have to live in that community. There's asbestos in that building. It's shockingly low, the bid that was selected. It's shockingly low because the other 2 bids were multiple times higher. I don't know how. There's been evidence that has come out, and I know we have a limited record, but that there's a lot more asbestos than that bid accounts for. These are the folks that have to live in that community, have to breathe that air, have to drink that water from that lake across the street. They want to know things are done right. And the West Bloomfield School District didn't do that. They weren't transparent. I get it. It's a controversial topic, right? Do it the right way. So in part, it's about the March 18th hearing. In part, it's the September 18th hearing. There was deliberate misrepresentations. If the trial court had watched that decision wasn't final. It's super convenient for West Bloomfield School District to say now it was final then. But that's not what their client was saying repeatedly at the September 18th meeting. They repeatedly reassured the public. Their quotes are in our brief. This will be revisited.
Okay, I have 2 follow-up questions. First one is, did the plaintiffs concede at the March 27th, 2024 hearing in the trial court that they were seeking to invalidate the board's decision made at the March 18th meeting only?
No, I don't believe that we did. I believe if it reads that way, that was not the intent. We believe that upon review of the video, that there were promises repeatedly made to the public at the September 18th meeting that decision wasn't final, and therefore it comes under the gamut of, if it wasn't finalized then, under their own admissions, then it was final at the March 18th. So I guess the way we look at it is with respect to the bids as asbestos abatement and demolition, those are certainly within the statute of limitations on the count 3. On the September, it's a question of fact, I suppose, about were there promises made that induced the public to rely on those promises at the September 18th meeting that kind of comforted them in the way that they didn't have to go out and seek an intervention at that point. They didn't have to go file an Open Meetings Act case because they were promised that it wasn't final. I know the story now is it was final, but that's not clear if you watch the record. Does that answer your question, Judge?
Thank you. And then I have just one follow-up question. Sure. Can you explain to me why the trial court determined that it lacked jurisdiction to address the question of demolition?
I never understood why the trial court believed it lacked jurisdiction to cover demolition. I think it was the trial court looked at this attorney general opinion that said that a school district can delegate some authority with respect to choosing a contractor. And she read that to trump the Open Meetings Act, to trump Booth, to trump Pine Brook Warren. In fairness, at the time of the hearing, Pine Brook Warren wasn't published law. I understand that. And I think that's in part of the problem. And we brought that up in the brief. She was relying on cases that they cited, although she didn't expressly say she was relying on them. The intent and kind of the analysis, if you go back and look at them, she followed that to come to that conclusion. But after that came out, that case law was set aside by Pine Brook Warren. It was specifically rejected. And so I don't think an attorney general opinion trumps Booth, trumps Pine Brook Warren, and trumps the case that came out in December out of this court, Exclusive Capital Partners. If the West Bloomfield School District would have said, hey, Superintendent Jamie Stylemaris and Auk, go out and look at these companies and let's talk about what you found and what your recommendations are at the next public board meeting. Let's have the public be able to engage in that discourse. They'd be okay. They didn't do that. Hawkins and Stottlemyre made a decision and the board rubber stamped it on March 18th.
Thank you.
Any other questions?
No question.
You have some time for rebuttal. Thank you very much.
Thank you.
Thank you.
Thank you.
Good morning, Your Honors.
Morning.
Lindsay Hazen on behalf of defendants, appellees, the West Bloomfield School District, Stacy Brickman, Nelson Hirsch. As Brother Counsel said, most of the issues have been pretty extensively briefed, but I do want to address a couple of his points and highlight a few issues for the court. The Board of Education's decision to demolish the former site of Roosevelt Elementary cannot be undone at this point. First, the decision occurred on September 18th, 2023. The time to challenge that decision had long passed by the time that plaintiffs or appellants brought this action in court. That 60-day statute of limitations after the minutes had been published had long passed. So there's no jurisdiction to invalidate that decision. Second, the decision to demolish the site was done in the proper manner, in compliance with the Open Meetings Act, in compliance with the revised school code. And third, even if an OMA violation is found in connection to that decision, at best, appellants are entitled to fees, costs, perhaps an order enjoining the defendants from further violation, but in no event is the decision to demolish eligible to be invalidated. So really, we are talking about that March 18th, 2024 alleged OMA violation. Then that was when the board voted to award contracts for the asbestos abatement and the demolition of the Roosevelt site. But still, appellants haven't actually identified anything done in secret in regards to that decision. Indeed, in compliance with the revised school code, which has a specific bidding process outlined, that's 3801267, the district advertised for the bids in a newspaper. That advertisement included the time, date, place those bids would be opened by the board or its designee pursuant to the statute. And those meetings are held publicly. Those meetings, in this case, were attended by at least one of the named plaintiffs. And so complying with the process in the revised school code doesn't contravene notions of the OMA. Indeed, that process is done in the public eye. And it's a process undertaken frequently, perhaps every day, by school districts across the state. So AUC's job, the construction manager as the expert in the field, is to see those bids and confirm they are viable, confirm these are real businesses that it can accomplish what the district is seeking. And then, pursuant to the law, they recommend the lowest, most responsible bidder to the board because fiscally it makes sense to go with the most cost-effective option. And that's exactly what happened here. The lowest responsible bidders were recommended to the board. And prior coming to the board, they weren't ranked, they weren't scored, they weren't substantively evaluated or compared or deleted. And that's really what distinguishes this case from the legal precedent finding a violation of the OMA for an improper delegation of authority. For example, in Pine Brook v. City of Warren, our Supreme Court held in what they characterized as a narrow holding, that the committee in that case triggered OMA obligations because of the way they acted, because they engaged in scoring and ranking that effectively determined what licenses would be awarded. So contrary to that process in Pine Brook or the process in Booth, I apologize, here no one eliminated options. No one provided substantive comparisons. They merely used their expertise to confirm the validity of the bids and pointed out which one was the lowest. I would add that this court's recent affirmation of this precedent in exclusive capital partners doesn't change the law. And in fact, on page 18 of that opinion at footnote 8, that panel determined a work group that assisted the public body in deliberations did not, standing alone, qualify as a public body under the OMA because no public body delegated authority to it and it acted only in an advisory capacity. So at most here, we have a group of individuals that are not happy with the decision the board made with respect to this building. A building that is not a historical building by any recognized designation, but members of the public, they have power when they don't agree with a decision. They get to vote. They get to vote for board members that align with their ideals that they want to see representing them on the board. but they don't get to dictate exactly how board members deliberate or exactly how they decide what exact decisions they make. So I'd also like to point out that appellants' arguments regarding the questionable asbestos abatement of Roosevelt are quite frankly disingenuous, because they purport to take issue with the company chosen for the abatement, and they purport to take issue with this bidding process that the school district undergoes. But appellants were noticeably quiet when the exact same asbestos abatement company was awarded the bid to demolish another elementary school in the district during the pendency of this appeal. Indeed, in the interim, the district has abated successfully with no issues or complaints another elementary school built in the 1950s, and they're in the process of finishing that demolition. So if appellants truly believed that defendants were engaging in ongoing OMA violations, that this bidding process was in violation of the OMA, surely they would have opposed that decision. To address a couple of opposing counsel's points, I would just like to point out that I don't think that there's any admission that the judge did not watch the videos in this case. The judge issued a very lengthy opinion where she considered the evidence. I know that appellants point to a quote, but I quite frankly think they're mischaracterizing that quote. And she was responding to counsel that she went on the board website and indeed saw documents. She would have viewed that board website sometime in March or April when documents were there, but that does not in any way mean that she didn't view the videos. I have full confidence that she viewed all the evidence in this case. And to your point, Judge Garrett, too, on page 7 of Appellee's brief, quoting our Exhibit C, the transcript from that March 27th hearing, appellants admitted, quote, I don't believe that we can directly attack the September 18th meeting to set aside the decision, end quote. So I do believe that they conceded that they can't attack that decision or invalidate that decision, rather. So if the panel doesn't have any further questions for me, I can wrap up with a final statement. Otherwise,
I have
yes,
a question.
Please.
Based on what you're saying today, which of plaintiff's claims are actually at issue here, since not all of the claims relate to the March 18th, 2024 board meeting?
Sure. Well, we're here on a preliminary injunction, right? So we're trying to really determine if they are, as the bringers of the motion, likely to succeed on the merits of their claim. And so when we're looking at, we have the OMA violations for September, which there's no jurisdiction to invalidate those claims. There's a FOIA violation, there's a public nuisance claim, and those were addressed by the court. And really, it seems like the bulk of the argument has to be brought down to if they would succeed on that March 18th claim. And even if they would succeed on that claim, at most, the remedy is going to be the board will vote again on who is awarded the contracts for the abatement and demolition of the building, and perhaps fees and costs if that is ultimately found. But in terms of preliminary injunction specifically seeking to prohibit the school district from abatement and demolition, none of their claims would provide them that relief.
Okay, thank you.
Yeah. I would just wrap up really quickly then, unless, okay. It would be outside the range of principled outcomes to conclude any of the claims would result in invalidating the September 2023 decision of the board to demolish. Thus, a preliminary injunction or further stay prohibiting the abatement and demolition of the building during the pendency of this action in the trial court is unwarranted. For those reasons, we would ask this court to affirm the trial court's ruling, denying appellant's motion for a preliminary injunction and dissolving the temporary restraining order. Thank you.
Thank you.
Thank you. Very briefly. With respect to Sister Council's points about the September 18th meeting, and it's too late now. On pages 20 and 21 of appellant's brief, section 2E, we detail the promises and the statements made by the school district board members, multiple of them, multiple statements that the decision was not final. With respect to exclusive capital partners standing in footnote 8, what that court found when you go read that case is that it wasn't that it was the delegation by the city council to the city manager. That was the delegation of authority. The city manager is the one who narrowed the options from 31 to 2. The city manager happened to employ some help in the form of a work group. What the court held is that the delegation to the city manager was the delegation of authority that brought the city manager under the Open Meetings Act, and not the work group alone. So it's a distinction without a difference. And with respect to what the court admitted, the trial court admitted, it's Exhibit C of appellee's brief on appeal. It is page 10, quote, me speaking to the court with respect. I think that you were provided with the March 4th hearing to view and the March 18th hearing. I think that they did not show, and the court cut me off, the court, quote, and at the beginning of every hearing, they announced that, all the information is on the website. All I did was look at the website, end quote. I think that's the court saying that she didn't look at the videos. Unless you have questions, that's the only 2 points I had.
Thank you very much.
Thank you.
Thank you very much.
This case will be submitted just for the public and for people watching online. The process for this is that we deliberate and an opinion's issued. The second it's issued from this court, both attorneys get a copy right away in their email. And so they'll be your point of contact. The opinion will also be posted online, as will an audio link to this argument. So if you go on the court website, it'll just be audio. If you go on YouTube, it'll be audio and video for people who couldn't watch the live stream or want to revisit these arguments. As stated earlier, I'll give everybody time to exit if you want to. And if you want to stick around, you're more than welcome. Thank you very much.
Oh, thank you. Nice to see you. Good. Yeah, Tim's on his phone.
Thanks everyone for indulging that transition period. I'm going to go ahead and call the next case number 15, 366281, Albert Sobotka versus Olympia Entertainment Incorporated. You may proceed.
Good morning. Margaret
Morning.
Carolali on behalf of the defendant, and I'm joined with my co-counsel, Dan Cohn. Good morning. As the court knows from the undisputed record in this matter, plaintiff was the operations manager at Little Caesars Arena. He was terminated on February 2nd, 2022, after he was caught urinating in his workspace in Little Caesars Arena instead of the men's room, which was approximately 60 feet away. An employee walking by saw this, reported it to HR because he believed it was inappropriate, and HR conducted an investigation. Plaintiff admitted his misconduct. He admitted that what he did was a huge mistake. In his deposition, the plaintiff admitted that as a manager, he was expected to lead by example, and that the company would be rightfully concerned that its employees could be exposed to employees urinating in the arena other than a restroom. Plaintiff admitted that there is no written or unwritten company policy that permits a manager to urinate where he urinated. No one gave him permission to do so, and that the company has the right not to have its employees urinate in the building other than in a restroom. Now, the undisputed record also shows that Keith Bradford, who was the vice president of operations, the leader of the department, made the decision to terminate plaintiff, and Mr. Bradford explained his reasons. An employee urinating in an open workspace with potential for other employees to see it is an offense that should be terminated. It just can't be allowed. It's egregious, and that's not something that's acceptable at work. On this record, we believe that the trial court correctly ruled on two aspects of defendant's motion for summary disposition, but committed reversible error on a third ruling, and I'll take those very briefly one by one. The trial court correctly ruled that plaintiff could not establish a perceived disability discrimination claim under the Michigan Persons with Disabilities Act, and the trial court properly dismissed count 2 of plaintiff's complaint. That ruling was correct because plaintiff's own deposition admissions belie the existence of a covered disability under Michigan law. He admitted, I can do anything. His condition never stopped me from anything. He never told anyone that he was limited in any way by a prostate issue, and he only vaguely mentioned it one time after his misconduct because he thought it would save his job. He admitted that the condition was not serious enough, and he first raised it with his own doctor 1 month after he was discharged. As the trial court correctly noted, plaintiff admitted in his deposition that he could control when and where he urinated at work. And the trial court found that plaintiff testified that he did not have an uncontrollable urge to urinate because he admitted he wouldn't have done it if he had been warned not to do it. These admissions are dispositive of plaintiff's disability claim because, put simply, plaintiff cannot show that anyone in management, much less the decision maker, Keith Bradford, perceived plaintiff to be statutorily disabled, because plaintiff's own admissions show that plaintiff did not perceive himself to be so disabled. And what's critical is that there's no notice at the time of the company's decision of any statutory disability. It was simply a vague reference to a generalized ailment, which the courts, including the Sixth Circuit in the Herdlicka case, which we discussed in our brief, said is not enough to state a claim under the Michigan Persons with Disabilities Act. In fact, the Herdlicka decision also supports that the vague reference to a generalized ailment was also too late. In Herdlicka, the court said, when an employee requests an accommodation for the first time, only after it becomes clear that an adverse employment action is imminent, such a request can be too little, too late. My second overriding point is that the trial court also correctly ruled that the company satisfied its burden to establish a legitimate, non-discriminatory business reason for its action, namely plaintiff's admitted misconduct in urinating in the workplace where an employee walking by could, and in fact did, see him. And that was a legitimate reason supporting the company's decision. We believe that trial court ruling was correct. Now, under the McDonnell-Douglas burden shifting, this ruling shifts the burden to plaintiff to prove by admissible evidence that the legitimate reason for his termination was a pretext, and because Michigan is a pretext plus state, and that the motivating factor for the decision was plaintiff's age as opposed to his admitted misconduct. And plaintiff cannot do that, cannot meet his burden on this record, and we believe that is where the reversible error occurred below. So my third point is that the trial court erred in finding a jury issue on pretext based solely on the level of discipline the company imposed for plaintiff's admitted misconduct. What the plaintiff is really saying here is, if you just wrote me up, if you just warned or admonished me for the same behavior, there would be no statutory claim of age or disability discrimination. And that puts the issue squarely within the business judgment rule. Plaintiff's repeated argument that he's entitled to a lesser penalty for behavior that he admitted the company has a right to prevent upends well-settled Michigan law. Now, I know this panel has read the briefs, but when you look at the cases that plaintiff cites in support of his pretext argument, they all involve situations where the underlying behavior, the what happened, was in dispute. For example, they involve situations where the plaintiff challenged the foundational facts upon which the employment decision was based, and through pretext showed proof that that's not really what happened. My point, and here's my point, the what happened is not in dispute in this case. Plaintiff admitted his behavior, and he admitted that the company had a right to prevent this type of misbehavior in the workplace. And Judge Denise Page Hood aptly summarized Michigan law when she stated in Martin v. Kroger, and I'm quoting from Judge Hood, even if the disciplinary decisions were perceived as somewhat harsh, given the employees with excellent performance histories, that does not provide a legal basis for concluding that the actions were motivated by discriminatory animus or pretext, at least in the absence of something more. There is no
This isn't in the absence of something more. There is something more. There's a supervisor making a comment on plaintiff's age, negative comment on plaintiff's age in advance of his firing. And there's the fact that plaintiff was replaced by a younger person.
And I would like to address both of those, Your Honor. There is no something more in this record, and if I can present argument on that. And the trial court's ruling allows the jury to do just that, second guess the level of discipline. There is no proof in this record that any younger, non-disabled employee was treated differently or more favorably than plaintiff under same or similar circumstances. And the absence of that proof is fatal to plaintiff's claim of age discrimination because it dispels any jury submissible inference of discriminatory treatment. This court ruled in Dumas versus Providence Hospital, where the plaintiffs who were fired for admitted misconduct failed to show any pretext. And the court ruled the plaintiffs all admitted to committing the offenses for which they were fired. Whether they thought they were justified in so acting or that defendant overreacted by firing them does not take away from the fact that termination for these violations were within defendant's policies. Plaintiffs presented no evidence that persons outside of the protected class were treated more favorably. That's why the cases plaintiff cites are distinguishable. Those cases involved admissible proof at the pretext stage of similarly situated non-protected employees who were treated more favorably. Now, and this is where I'd like to address the court's observations. Upon learning of plaintiff's behavior, Keith Bradford, who ran the department, his immediate reaction, and this is undisputed in the record, his immediate reaction was that this type of behavior by a manager will likely lead to termination. He allowed HR to do its investigation, but he testified, and it's undisputed, the minute he heard about the behavior, in his mind, this would lead to termination, and he was the decision maker. And here's the thing, plaintiff had the same immediate reaction. Plaintiff testified that on February 4, when he was confronted by HR by his misbehavior, and he admitted it, plaintiff testified that he knew that day that he was going to be fired. So both plaintiff and the ultimate decision maker had the same immediate reaction to plaintiff's misconduct.
Isn't Bradford's testimony contradicted by Padgett? And Bradford basically says, well, I didn't get any opinion from Padgett about this decision, and yet Padgett testified the exact opposite.
I'd like to address that. Thank you. I'd like to address that right now. Plaintiff spends a lot of time in his brief speculating about and it is speculation, if I may make argument on that point. Plaintiff spends a lot of time in his brief speculating about a one-time, offhand, purported comment by Tim Padgett in a group meeting. Plaintiff's argument does not create a jury issue of age discrimination because it's based on conjecture, not evidence. There is no admissible evidence, none in this record, linking any purported comment by Tim Padgett to Keith Bradford's ultimate decision to terminate plaintiff for his misbehavior. There's no evidence, nothing in this record, and plaintiff does not cite to any, showing that Keith Bradford was even aware of that purported one-time offhand comment by Tim Paget.
Well, we can agree that their two statements, one of them is wrong, right?
Well,
One
I
of them
think,
is either mistaken or testifying falsely, but those two things can't be true. Where person A says, yeah, this gentleman never told me anything, and then the gentleman testifies that, in fact, I did tell you that.
I think they're two different, and the record will show those were two different decisions. One is who made the decision and who participated in the decision to terminate. But I would like to go to address, Judge Wallace, your question. And if I may present argument on that, and then I'd like to answer any questions you have on that. There's no record evidence that Tim Paget influenced Bradford's decision to terminate plaintiff, just the opposite. And I think this is where there has been a repeated misconstruing of the record, and I'd like to elaborate on that. If there was any influence, it was Keith Bradford, who ran the department, who influenced Tim Paget that plaintiff's behavior was wrongful and warranted termination. And Your Honor, this is what I'd like to go to your point. Paget testified that he and Bradford had a conversation about plaintiff's behavior. And this conversation about plaintiff's behavior occurred before HR made its recommendation to Keith Bradford, who was the decision maker, and where HR recommended termination. Paget testified that he and Bradford had a conversation about plaintiff's behavior. It was Bradford who explained to Paget in that conversation that he, Bradford, previously fired colleagues at a prior company for doing the same thing, and that he, Bradford, thought it was a fireable offense. Paget testified, and I point to 133 of Paget's testimony. Paget testified that after listening to Keith Bradford, Paget said it was crystallizing even more so for me that it was a terminable offense. There's no record evidence that Paget influenced Bradford. It's just the opposite. It was Bradford explaining to Paget why he, Bradford, who made the initial reaction that this is going to result in termination and ultimately made the termination decision. It was he, Bradford, that was telling Paget, this is why this behavior is a fireable offense. And I'd like to reserve some time for a rebuttal, but as I conclude here, when I've listened to many of the plaintiff's arguments, and I have been a practicing employment lawyer for 40 years, when I listened to many of plaintiff's argument, I felt like I was in a time warp. In the late 80s and through the 90s, employers implemented internal reporting procedures so that employees who felt that there was misbehavior in the workplace could report that misbehavior. And employers were routinely faced with arguments like, what's the big deal? No real man would be offended by that. Nobody got hurt. Nothing was damaged. Boys will be boys. The record here shows that an employee saw plaintiff's behavior, a manager was offended, reported that behavior. HR did an investigation, and HR's investigation is part of the record. HR interviewed the ICE crew. ICE crew said, that's gross. And one ICE crew, and it's in the record, member said, I sure hope that's not happening because I got to get on my hands and knees and clean that space. My point is that there's nothing in the Elliott-Larsen Civil Rights Act that says the misbehaving manager's opinion about the proper level of discipline for his admitted misconduct supersedes the employer's business judgment about the appropriate consequences in the workplace. And I will tell this panel, I am concerned if that now becomes the applicable standard, we are going backward. And I will reserve unless the panel has questions.
Thank you very much.
Thank you.
Good morning, all.
Good morning.
So what you just heard from defendant was this. sweep aside the law in the state of Michigan that has been in existence since the 1980s or earlier, because they have said 2 words or 3, Al urinated in a drain, stop, end of story. We call that a legitimate business reason. We, Olympia, and none of you should second guess it. That is absurd. Let me explain to you how this works in Michigan. Plaintiff must come forward with a prima facie case. Plaintiff, prong 1, protected class, age, race, gender. Here I have age. 2, adverse action. 3, qualified for the job. 4, replaced by a younger person. That's the prima facie case. We made it out. The burden then shifts to defendant. The defendant gets to say to the court, hey, we have a legitimate business reason. In many cases, the legitimate business reason is, hey, the person we picked over you was much better qualified, and nobody ever mentioned your age. That's a legitimate business reason. Their reason is hardly legitimate, and I'm going to get to that in a minute. Urinating behind a Zamboni machine is not. A 50-year employee that has an excellent record, who 2 weeks earlier was rated as ethical, honest, top flight. They don't have a legitimate business reason. But for purposes of the law, let's say they've articulated a legitimate business reason, just like the circuit judge noted. She said then, but it could be a pretext. So prima facie case, legitimate business reason. That's the first step. Second step, here's the third step. The burden shifts back to the plaintiff to show that the so-called legitimate business reason is a pretext. Okay, you have to set forth facts. To say I have facts is an understatement. I'm going to tick through a list for you all of the absurdity, the falsehoods, the utter lack of credibility with which this defendant has proceeded. Obviously, they wanted Al Sabatka gone because of his age. 3 days before this happened, he was told point blank by Tim Padgett, you're too old. Now, part of the lack of credibility that comes from defendant, which is overwhelming, is because they keep trying to cordon off Tim Padgett, the person that made the discriminatory comment from the decision. So their whole theory is, no, 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 it was all Mr. Bradford, who just arrived here recently from Disneyland, literally, and he worked there, and he made the decision. Okay, that is not the facts in this case. Let me roll into what actually occurred here. First, pretext can take a variety of forms. There's no particular requirement in the law. Pretext is a common sense inquiry. Did the employer fire the employee for the stated reason or not? The law does not require that the court accept any reason articulated, no matter how illogical or unsupported. The significance of the disbelief pretext will vary depending on the circumstances. Everything depends on the individual facts. 2 very important Michigan cases, Town and Hazel, Michigan Supreme Court cases. That's what they say about you all analyzing pretext. Now, let's look to pretext. In addition to what I just told you, the courts are very cognizant of the fact that false statements can be disbelieved. Credibility goes into pretext, members of the panel. Credibility is paramount. Town, we note, in accordance with 9 other circuits, evidence sufficient to discredit a defendant's proffered non-discriminatory reasons taken together with the prima facie case, which they don't say, we all agree we have it, may be sufficient all by itself to support a finding of discrimination. Reeves versus Anderson, United States Supreme Court. Prima facie case combined with evidence that the reason is false is enough. Now, to remind you, their whole world is Padgett has nothing to do with this. I've got to be direct about this. In the brief, they're flatly misstating facts. Let's start with the misstatement and who they say is the decision maker. They say Bradford is the decision maker. On page 23 of their brief, they say the record contains no evidence that Paget played any role, let alone a significant one, in Bradford's decision to terminate plaintiff. Hold that thought. Next, they say there is no evidence that Tim Paget influenced Bradford's decision. The decision to end plaintiff's employment was made by Bradford during a one-on-one meeting between Michelle Bartos, she's HR, and Bradford. Now, listen to this carefully. Bradford and Paget never discussed plaintiff's termination. That's what they say. Nor is there any evidence in the record that Bradford was in any way influenced by Paget, a non-decision maker. Plaintiff cites no record evidence. Now let's go to the Paget depth. I asked him, this is after they say Paget had no input, they never discussed it. Question, I just want to know the people who gave you your opinion to Mr. Paget about Al Sabatka's termination. Answer, Keith Bradford, Rob Carr, counsel was sitting at the table, Michelle Bartos, Jim Bulow, and Jasmine Howard. I don't know what to say to these people when they say Bradford and Paget never exchanged information. That was question number one.
Page was that on the brief?
That was page 52 of Paget's brief. Paget then says, I felt...
Of Paget's step, right?
Paget's step, I apologize. Thank you, Your Honor.
Yeah.
I felt it was a terminable offense. Question, I just want to know if that is what you told Bradford. Answer, yes. I thought it was a terminable offense. Can you give me a reason why nobody gave Al a second chance? Answer, because I thought it was a terminable offense. I mean, that's my reason. There's no second chance. That's Brad Paget at 89. Now, there was another little snag for defendants in this case. They also wanted to keep Chris Ilitch out of this. This went all the way up to Chris Ilitch. That's uncontested in the facts. And I wanted to depose Chris Ilitch. Hence, the defendant came up with a theory to try to stop me. And they got an affidavit from Keith Bradford. And in this affidavit, Keith Bradford says to all of us under oath that what he did is he had extensive discussions with Mr. Paget, but not Mr. Ilitch. So I have an affidavit. It is defendant's exhibit, I'm sorry, 14. Our exhibit number 14, where in the affidavit, Bradford literally says, I had extensive discussions. The lack of credibility on this point is overwhelming. Now let me get to other pretext. The decision, they say that my client admitted he should have been fired. Their whole point is based on the following testimony. Al Sabatka was called in to a meeting and asked, did you urinate behind the Zamboni machine in the Zamboni garage at 8:40 a.m. in the morning after a Red Wings practice where there were literally 3 other people in the area, 0 public? To which he said, yes, I did. At that very moment, they walked him out of the building. This is when Al formed the opinion I believed I would be fired. He never for 1 minute thought that anything he did was a terminable offense. Okay, a couple days later, Al is still off on suspension. And by the way, why he's on suspension, there's supposedly an investigation going on. This is their testimony. 16 days go by, but I have their privilege log, Exhibit 8. Over the 16-day period, there were 26 meetings about this between general counsel, outside PR. There was discussions about our legal strategy. There were discussions about what are we going to do with the public when the announcement comes out that Al has been terminated. This is our Exhibit 8, members of the panel. There are multiple emails that Chris Ilitch is now involved in this. Tim Paget attends at least 5 of these meetings. This is the so-called investigation that they did. Why did they do this? The decision to terminate Al was preordained. Why? Because of his age. Hence, when they put Al out on suspension, he really was fired. He was never coming back, as the privilege law clearly shows. They were creating a legal strategy. You can go through each line item and you can see that's what these people were doing. They were creating a legal strategy and a PR strategy. Okay, Al calls on the 8th, a couple days later, and he says, listen, guys, he talks to HR and he says, I have a prostate problem. I've not been treated for it, but I want to tell you, I think that's what caused this sudden urge. This has never happened to me before, and I want to let you know. HR made a note of it and never took any other action. Now, if defendant's correct and they were really so horrified that Al urinated behind a Zamboni machine, what would they have done? They would have called Al and said, wait a minute, wait, you've got a prostate problem? Why don't you get a doctor's note and we can take it from there? Let's look at this further. They didn't do that. There was zero follow-up whatsoever. Next, the personnel record and the termination letter are literally devoid of anything in writing, anything about anything Al did wrong. This is uncontested. The Bulow Dep at 39, all is verbal. Next, they say Al used poor judgment, but I asked the head of HR, but not everyone who uses poor judgment gets fired. Is that correct, Ms. Bartos? She said, that's correct. Al Sabatka is the only employee out of roughly 200 employees who has ever been fired for anything that we could discern in discovery other than using racist language to customers would be one, or doing physical harm to another. There's a clear difference in treatment here. Next, I have testimony, direct testimony from the supervisors that warnings and suspensions are often used. This company has an extensive personnel policy. What's the exhibit number on that, Sarah? It's we give you the booklet, most of the booklet, and there are roughly 36 items listed in the handbook. It's number 12, exhibit number 12. There are 36 specific items. These people go into great detail. Dot every I, cross every T. Nowhere does it say in here anywhere anything about this. Now, they may say, well, it's still not right. Okay, fine. But the courts do look to, is there a policy in place that the employee violated when you're looking for pretext? Let's look and see if at least it's a policy violation. They do not reference a rule. Now let's go on to progressive discipline. They make a big deal about this. Progressive discipline is clearly used by this company. Both Boulos and Padgett testified extensively. They give written warnings. They give second written warnings. They give time off. They give write-ups. That's absolutely uncontested. Progressive discipline is regularly used. And I want to speak about progressive discipline in the legal context as well. Decision not to use progressive discipline in a pretext analysis is wrong. That's of Summers Wilson on page 38 of our papers, our brief. Hence, the lack of progressive discipline on something so innocuous and inane as a man who has a prostate problem. You saw the pictures in the brief of the garage. No harm to property, no harm to a person, no harm to equipment, no lost work time. They admit this in their DEP. There's literally zero harm that came to anybody based on the action that they fired my client for. Next, no investigation into what Al did wrong. No investigation. Nobody ever interviewed Al other than to say, did you do this? And he said yes. No further discussions whatsoever. Jim Bulow was Al's direct supervisor. He was also a bit of a friend of Al's. They'd known each other for a long time. I deposed Bulow. I said, Mr. Bulow, Al's a great employee. You agree. Why did you not go to bat for him? Why did you not vouch for this long-time subordinate? This is the quote. I believe the die had been cast. Didn't matter what Bulow said. The die had been cast. That's Bulow Dep at page 117. A few weeks earlier, Al had gotten a review, highest standards of ethics, integrity, doing what's right. Now let's go to Bradford, who they're hanging their hat on, the man who had just arrived on the scene from Disneyland. or Disney World. I'm not sure which it was. Never met Al. Never called Al in. Never said, Al, hey, what happened, buddy? Longtime employee, great record. What happened here? Didn't know anything about Al. You'd only seen him in passing. Bradford did claim, though, that he has many factors he looks at when he's analyzing whether somebody should be terminated. Length of employment, the work record, loyalty. What discipline would ensure that this doesn't happen again? None of those factors were taken into account with regard to my client. When asked, this is important, I think, I asked him, why didn't you just tell Al Sabatka, don't do this again? Isn't it true that if you told Al Sabatka that would never happen again? He said on page 122 of his DEP, this is Bradford, I don't have any reason to believe Al would have directly disobeyed me. So what more can you say? We have an admission from their alleged decision maker that a simple don't do it again would have resolved the problem. And this is what the trial court found. The trial court found that the severity of the discipline was very suspicious to her. That wasn't her word, that's mine. But she said, that's very concerning to me. The level of the discipline and severity of the discipline is also important legally. You can look at the case of Volcraft Sales Corp, 830 Fed Sup. It's in our brief, 1017 Western District of Michigan. The severity of the discipline may be evidence of discrimination. The district court erred in concluding that the severity of plaintiff's discipline did not provide evidence of discrimination. Howley versus FedEx, 6th Circuit, 2017, also in our brief. The court found the circumstances surrounding plaintiff's termination suspicious and giving a rise to a negative inference of age discrimination, even where the defendant stated it had legitimate reasons. The court is struck by the relatively minor nature of plaintiff's offenses and wonders whether any of them merited termination. So these are legitimate questions. And this is the bottom line. These are questions of fact for a jury. Michigan Civil Jury Instruction 105.03, employment discrimination. Cautionary instruction as to business judgment. Your task is to determine whether the defendant discriminated against the plaintiff. You are not to substitute your judgment for the defendant's business judgment or decide this case based upon what you would have done. However, you may consider the reasonableness or lack of reasonableness of defendant's stated business judgment along with all the other evidence in deciding whether or not plaintiff was discriminated against. Hence, this is a question of fact. The cases defendants want to rely on are those such as Martin versus Kroger. Here you had an employee, a Kroger employee who was shopping on the clock. She said, I'm sorry, I shouldn't be fired for this. The defendant's business reason was you were shopping on the clock, and she felt it was discrimination, but Kroger was able to show members of the panel that this was an ironclad policy in writing that they had applied to multiple other employees over time. Within the past 2 years, they had 13 employees that they had also fired for shopping on the clock. Nor do I have to show that a younger person was treated differently. That is simply one way to prove discrimination, and defense counsel is just flatly wrong that that is part of the requirement. When it comes to business judgment, again, business judgment is trumped if the plaintiff has enough evidence to show pretext. As to the disability claim, I'm going to rely mainly on my brief because of time. The fact of the matter is that when my client called HR to say, I have a prostate problem, I'm going to go get treatment, and she made a reference in her notes, defendants became aware that Al had a disability. Our theory is that he was regarded as having a determinable physical or mental characteristic. Part of our theory is that the company clearly viewed Al as old. The prostate issue is evidence of that as well once he called. Now, they say they hadn't made the decision by February 8th. He was walked out on February 4. That was a Friday. Al called, I think, the following Monday. Now, a defendant says they hadn't made the decision. I personally believe the decision was made, and I think the jury will, on the day he was walked out. But according to them, they had not made the decision. So when Al called HR and told her about the prostate issue, that was direct evidence to the defendant that our client did have a prostate issue, and that should be taken into account with regard to a possible accommodation for him. And this condition, a plaintiff who sets forth evidence that he must be free to go to the bathroom wherever he feels the urge is significantly restricted, can be considered perceived as disabled under the law. So that's, the judge, did dismiss our claim on that. The judge did the right thing as to finding that there was a question of pretext. And I don't know how much time I have left. Defendants will never be able to say to you in any legitimate way that there is not a really significant question of fact here. These facts are so strong that, possibly we could have filed the motion for summary judgment. Unfortunately, we did not, because of the falsity of their reasons and the fact that they have literally nothing to hang their hat on. But at the end of the day, it really will be a question of fact for the jury. Appreciate your time.
Thank you.
I have a quick question.
Oh.
Before you sit down. I know you ran out of time, but with regard to if you had more time with regard to the reference to the Kroger case, you're basically saying that none of the other people who had urinated into the similar drain that Joe Lewis had been fired. So under the logic of Kroger, that essentially he's being treated differently.
And you do have a couple minutes, by the way.
I'm sorry, Your Honor. Say that again.
Yeah. So you mentioned the Kroger case where it was kind of the opposite situation where Kroger had this policy about not shopping on the clock, and multiple people had been fired because they shopped on the clock. And so I guess if we juxtapose that with the facts of this case, where there's been testimony that there were multiple other employees that urinated into the Zamboni drain, not at this place, but at the Joe.
Mm-hmm.
So taking the logic of Kroger, it would seem that in that situation where everybody got fired for doing this behavior, whereas in this case, nobody got fired except for Mr. Sabatka, that it would show that he's being treated differently than other similarly situated employees.
Yes, but I didn't really want to rely on that simply because, there wasn't, that was the one thing that was investigated, by the way. And I don't know why HR took it upon themselves, but they did. They went back to the old Joe Lewis days, and they did have testimony from some of the individuals there that people did urinate in the drain. I don't think that's the most salient factor in this case, because there is no requirement on plaintiff that we have to show similarly situated people were treated differently, period, full stop. And I don't have evidence from an individual who will say, I urinated at the Joe. I can tell you that there are open urinals at Little Caesars Arena. I can tell you that. They have open urinals, that's in the record. And people are urinating in front of one another. But to your point, Judge Wallace, we do not need to find similarly. This is one way. Plaintiffs are always in the position where the defendant has all the witnesses and all the evidence, and we have to find a path to show that discrimination did occur, and showing that somebody similarly situated was treated differently is one path. Here, our theory is pretext, that Al Sabatka urinating behind the Zamboni machine in a garage, absolutely under the policies, procedures of this company, under the testimony of all the witnesses, is 100% not a terminable offense. 100% not a terminable offense. They have zero evidence that it is. As one more thing, as to their thing, which I hear over and over again, well, Al said it was a mistake. Al Sabatka is a non-straightforward guy. Did he think he made a mistake once he got fired? Yeah, just like if I leave here and take 75 instead of Woodward, and I've got to get to a dep, and I run into traffic on 75, I'm going to say, yeah, I made a mistake. I'm sorry, I'm late. I mean, that's what the mistake was. Al did nothing wrong. His employer latched onto this because they wanted him out. He's by far away the oldest guy, 50-year employee. Thank you, members of the panel.
Thank you. Rebuttal.
Thank you. I want to start with the distinction about who participated in the decision based on the record. And obviously, It's the record evidence that controls whether there's a jury issue, not argument, speculation, or conjecture. Based on the record evidence, Tim Padgett said he had a conversation, and I gave you the cites to Padgett's testimony, with Keith Bradford about the behavior. And in that conversation, Keith Bradford told Padgett why he, Keith Bradford, thought it was a fireable offense. And Tim Padgett, after listening to that, was influenced by Bradford and said, oh, that's a fireable offense. They were talking about the behavior. Tim Padgett, in his deposition, page 127, when he was asked, when did you first discuss this with Bradford, the termination? Padgett said, the termination? Yes. Or the whole topic, the termination. I don't believe I ever discussed the termination specifically with Keith Bradford. They were discussing the behavior, the what had happened. So the statement that Tim Padgett participated in the decision is not accurate. And I take note with plaintiff's counsel's attempt in this record to infer admissible evidence from a privilege log. Plaintiff was talking to his lawyer throughout this time period. You don't make adverse inferences, and you certainly don't create a jury issue by making adverse inferences about attorney-client privilege discussions, of the content of which was never disclosed, and the privilege was never waived here. But in plaintiff's brief, they repeatedly do that. That is not evidence. That is speculation. That is conjecture. There was argument that I just heard by Ms. Gordon that there was no investigation. Appendix M to the record shows there was an investigation. Was it relatively brief? Of course. Why was it relatively brief? Because plaintiff admitted the misconduct. A lot of times HR investigations are complicated because it's in dispute about what happened. The what happened is not in dispute here. Plaintiff admitted his misconduct. Plaintiff admitted that the company has a right to prevent managers from engaging in this type of behavior. And plaintiff can't create a jury issue by contradicting his own sworn testimony. I want to talk very quickly about progressive discipline. Again, I'm going back to plaintiff's deposition admissions because he can't create a jury issue by contradicting his own admissions. Plaintiff admitted that the company policies allowed the company to terminate people for a single instance of misconduct. Plaintiff admitted that at page 85 of his testimony. Plaintiff admitted that this progressive discipline policy stating in the handbook didn't apply to all situations. There is testimony in this record from Ms. Bartos and others that the company has terminated individuals for a single incident of misconduct. So the company has the right to do so. It did so here, and it has acted consistently in the past by terminating people for a single incident of misconduct.
I don't mean to put you on the spot, but
Sure.
If you remember off the top of your head, you said Ms. Bartos testified to that. Who else testified to that? If you recall.
I have the citation. Plaintiff admitted that the policy allowed for termination due to a single incident, page 85, 86. Bartos 107, 108. Bradford 22, 28, and Bulow 69.
Thank you.
So what we have is a record here that a single incident of misconduct and has occurred in the past. So there's consistency that a single incident of misconduct can lead to termination. I want to briefly reference, if I may, Your Honor, the reference to Joe Louis Arena.
Well, I think she kind of conceded that it's not really applicable here, but go ahead.
But it's
do
simply,
you pretty much agree with what she said that's not really
it's hearsay. It's something that nobody could point to, and it was all hearsay testimony and not admissible testimony. I want to
because it wasn't anybody who testified that they directly witnessed that.
Exactly.
Yeah.
The only testimony in this
it was some of it. I'm sorry, I've cut you off. Go ahead.
No, please, Your Honor.
I was going to say some of it was actually more like double hearsay or maybe triple hearsay.
Correct.
I heard somebody say that somebody said that type of thing.
I heard
Yeah.
that back at Joe Louis 8-10 years ago, maybe somebody did this. The only actual admissible evidence we have in the record is plaintiff's admission that he urinated in the arena. I want to briefly reference, because we discuss it at great length in our brief, but this concept of a stray remark not being admissible evidence of pretext. Stray remark, and that we've cited the cases, I won't repeat all of them, but it looks at, was the stray remark made by a non-decision maker unrelated to the actual decision at hand? Was it vague and ambiguous? And was it isolated? In other words, a one-time event. Tim Padgett's vague comment, and again, we don't have to look any farther than plaintiff's own testimony on that. Tim Padgett's vague comment, plaintiff's testimony was he couldn't even remember what he really said. He thought there was a word age in there. Plaintiff admitted that in response to Tim Padgett's comment, plaintiff responded, "Oh, he was too funny," and he laughed. So there's a vagueness about what Tim Padgett actually said. Of course, Tim Padgett denies saying that, but here's the point. There's nothing in Michigan law that says plaintiff can take a one-time offhand stray remark, which Padgett denies making, and create a jury issue where the alleged comment predated plaintiff's misconduct, did not relate to the decision at hand, which is what is going to be the consequence for plaintiff's admitted misbehavior, and was, and this is critical, I think this is pivotal, that stray remark was completely unknown to the actual decision maker, Keith Bradford. And the Supreme Court addressed a similar situation in a case, Sniesinski, if I'm pronouncing that correctly, where the court made it clear that there has to be some admissible evidence, evidentiary admissible evidence of a causal connection between the alleged stray remark and the challenged employment decision. And that's true in a direct evidence or a circumstantial evidence case. And conjecture and speculation doesn't draw that evidentiary bridge or link. Unless the panel has questions for me.
No, but thank you very much.
Thank you.
Thank you.
Thank you both.
This case is submitted. Now calling case number 16, 365768, Valerie Zavala versus Trinity Incorporated.
Good morning.
Morning.
My name is Nick Dragels. I represent the plaintiff appellant in this case. These are admittedly unusual facts, atypical liability case. We're here following a jury trial, two specific evidentiary rulings that I think tremendously and improperly impacted the jury's verdict in our case. First, what are we debating ultimately? My clients testified at trial, and our theory of liability is that a taxi cab was driven very erratically, words including taking off, speeding, flying around the parking lot, highly unusual taxi cab experience, a sudden deceleration for reasons unknown to my clients caused Arturo Zavala to be thrown forward and Valerie Zavala to be thrown forward from the back of the cab to the front, ultimately resulting in Arturo's blindness. Causation was also disputed in this case. There are only two witnesses who weigh in on liability in the case: the driver of the taxi cab, Mr. Shreve, and my client, Ms. Zavala. Arturo largely non-communicative. He said the word bang, quote, at trial, but otherwise did not testify about how the incident occurred. So the jury was faced with two very distinct versions of events. Mr. Shreve's was that he was traveling approximately 2 miles per hour, gently applied his brake as a pedestrian slowly walked in front of him. Very benign series of events, according to Mr. Shreve. And I've already explained to the panel, it's in my brief, how Ms. Zavala contends the incident occurred. The first piece of evidence that was not considered by the jury is what was called a driving out harm form. It's Appendix B of our brief. The trial court allowed cross-examination of Mr. Shreve using the first page only of the driving out harm form. And the trial court reasoned that the balance of the form could not be authenticated. Mr. Shreve admitted he wrote the first page, had no idea who wrote the rest of the form. 901 parent B, parent 4 is exactly the kind of authentication rule that applies to the driving out harm form. There are consistent markings. The pagination is consistent. The box marks are the checks that you have to make a selection next to various items on the form are all consistent. The name of, albeit misspelled, but the name of my client Valerie Zavala is on page 2 of the form. And importantly, on page 2 of the form, a narrative of events is put forth that differs wildly from Mr. Shreve's trial testimony. In the defendant's brief, they say, well, the only difference is in that page 2 description, it's talking about an animal instead of a person. And I think it, as I read the brief and thought about it some more in preparation for today, I think that perhaps the reason I set forward that argument was misconstrued as relating to damages or cherry picking animal versus person, and it's not it at all. In that and it's typed in our brief as well, but in the description of events on that page 2 from the driving out harm form, that description of events includes Ms. Zavala being thrown forward from the back seat. That doesn't happen at 1 to 2 miles an hour. It's a liability argument, not a damages argument. And it relates to the markedly different speed, not 1 to 2 miles an hour. I'm gently pressing my brake, no big deal. It talks about Valerie Zavala flying forward and banging her knee. That's consistent with what Ms. Zavala testified happened. And again, the speed and the unusual erratic nature of the taxi cab trip is the point of that page 2. And the jury didn't get to hear that. The jury only heard Mr. Shreve's version of events that said I was going approximately 2 miles an hour, no big deal. A person walked in front of me. I talk in the brief, the case law of Mitchell.
Before you do that, can you give us some context as to how you got this form and where you were procedurally in the case? I think it was mentioned that it was attached to a case evaluation summary. So I guess my questions are, was there a request to produce that where this wasn't produced, or was there no request to produce, and what kind of discovery was conducted after case eval?
Thank you very much, Your Honor. The form itself, I received, my recollection of this, of how I received it was that I received it through the defendant's case evaluation summary. That, I believe we went to case evaluation. I know it was before COVID. Maybe it was 2019, 2018, roughly, Your Honor. Mr. Shreve could not be located by either party throughout many years of the pendency of this case. Ultimately, he was located I want to say it was in like November of 2022. Years after discovery is closed, the case has already been to the Court of Appeals, I believe twice by that point, and returned to the trial court. And Mr. Shreve was deposed in a public library. During that deposition, I showed him the form, and he testified, yes, I did. I wrote the first page. He testified that he wasn't sure who wrote the rest of the report out during his discovery deposition. That again was December of 2022. This case was tried in March of 2023. Between December of 2022 and March of 2023, no challenge to the authenticity of the document was ever made to me. I never was aware of any challenge of the sort. And the document was referenced throughout the preparation leading up to trial. To answer the court's question directly, no specific discovery was conducted after December of 22 up through March of 2023. Certainly, I did not invite the consequence, as discussed in our brief. I didn't plan to cover too much of it during oral argument, but I certainly took no affirmative action to say that this document is inauthentic or otherwise. I had no reason to believe its authenticity was at issue.
But you knew 3 months in advance of trial that that the taxi driver did not take accountability for the last 3 pages of that report.
The only issue I would take with Your Honor's comment is that he did not write the last 3 pages. I did know that, yes, Your Honor. Okay. With respect to the driving out harm form, that second page, I think the Mitchell case lays out the steps that a proponent of evidence needs to take. And the first step is that it needs to be considered for authenticity. And to do that, plaintiff must, or the proponent must show a prima facie showing that a reasonable juror might conclude the proffered evidence is what the proponent claims it to be. And it need not be free of all doubt to be authentic. Ultimately, I think it's a question of weight, not admissibility, because of the overwhelming similarities, internally consistent similarities within the 4 pages of the form, as well as it can't be mere coincidence that my client's name and phone number are included on the second page, and a description of events sort of similar to her description of events is contained within the document. Also important to note for the panel, or remind the panel, this document was being introduced to impeach Mr. Shreve to show that his description of the events at trial were quite different than his or than the description in the form. And the jury could have made what it would. They may have bought it, they may not have, but they didn't even get the chance to consider that second page in that narrative, which I respectfully believe to be error. The other piece in the same vein, again, it's not a damages argument, it's a liability argument, corroborating the speed that my client says this incident occurred at. Ms. Zavala's injuries were deemed irrelevant by the trial court and not to be considered. To the extent Ms. Zavala testified about her own condition after trial, that testimony was ordered stricken and to be disregarded. Furthermore, there's mention made that we didn't move to admit the medical records. The motion in limine decided before the trial even began. The trial court clearly ruled Ms. Zavala's injuries are not relevant in this case. Simply following the trial court's ruling, I don't think was a waiver of the medical records issue. And the reason the medical records are important is not to include other litigation. I never intended to do that. It's not to show that because somebody else was injured, ergo Arturo must also have been injured. It is to show the accident did not occur at 1 to 2 miles an hour. It wasn't a gentle brake press as a pedestrian walked in front, but instead it was a much more rapid deceleration. Again, admittedly, atypical liability facts, but the incident itself occurred with more speed than Mr. Shreve testified, and that's supported by Ms. Zavala's trip to the emergency room where she makes complaints. Her knee is palpated and there's tenderness there, there's edema present. The jury didn't consider that. When you combine both of those things and consider that there are only 2 witnesses that are going to bear on liability, and then you further consider that the 2 pieces of evidence that are before this panel corroborate Ms. Zavala's version of events while simultaneously impeaching Mr. Shreve's version of events, it seems to me a substantial injustice that the jury did not consider these. That's not to say they ultimately wouldn't have no cause to us anyways, but they should have considered these facts and the evidence before the court. And that's all I have unless the panel has any questions for me.
Questions? Thank you.
Thank you very much.
For rebuttal.
Thank you.
Good morning. Excuse me, may it please the court. Tim Deemer on behalf of the defendant, Appellee Trinity. Also here with me is Sam McLeod, Associate Attorney for my office. I will be brief. We briefed this case extensively. No new case law has come out, no new authorities, no court rule changes, no rule of evidence changes. Nothing has changed what we briefed. I do want to highlight, though, that plaintiff faces 2 extremely high hurdles here. First, the high hurdle to show that the judge's rulings were an abuse of discretion, which was basically saying that Judge Hubbard's rulings were so out of bounds, they weren't even principled, fall outside the range of principal outcomes. Plaintiff can't meet that burden. And even if plaintiff did meet that burden, plaintiff has to show that these rulings deprived her of a fair trial. And under MRE 103A, that standard is very high. He has to prove that not setting aside this jury verdict would be inconsistent with substantial justice. That standard is not met here either.
Judge Hubbard was correct to admit into evidence page 1 of the driving out form and to not admit pages 2, 3, and 4. I know the panel picked up on that distinction. Mr. Shreve confirmed that's my handwriting. I signed page 1 of the form, page 2, 3, and 4. He has no idea who filled those out. Neither does plaintiff. Plaintiff had months to figure this out. So I try to identify who at National Express, who at Trinity, or maybe the TPA that Trinity uses, Sedgwick. Maybe one of them completed this form. Nobody knows. No signature, no date, no name, no nothing, no authentication as to what that document actually is. Judge Hubbard is correct to exclude on that ground, also on grounds of hearsay, to keep that out of this case. Again, abuse of discretion. Can we say that not letting this evidence, this piece of paper into evidence was not principled outside the range of reasonable outcomes? Absolutely not. And the Court of Appeals opinion in Lewis v. LeGros, when it's a close question on an evidentiary ruling, by definition, it cannot be an abuse of discretion. Again, in this case, I don't think it was a close question. I think Judge Hubbard was absolutely correct to exclude it.
You will admit, though, it's very unusual that your client produced an incident report and then claimed it was not authentic.
I'm not, okay, so on the one hand, I'm not sure I entirely agree with how it was produced at the case evaluation submission only. That is what the plaintiff has suggested. I can't vouch for that. But what is plaintiff?
But you don't dispute it came from your client. I mean, that's how they got it. They got it from your client, right?
That appears to be correct, yes.
So it is very unusual that they would get something that purports to be an incident report from your client, and then your client would turn around and question the authenticity of the very document they produced.
The authenticity is, what does that incident report, let's just say, yeah, it was a National Express incident report, so it does appear to be. But they meaning plaintiff, is suggesting that that incident report, page 2 in particular, was a statement of Mr. Shreve, which we don't know. We don't know where that information came from. We don't know who transcribed, if it was based on a statement, telephone conversation with Mr. Shreve. So again, how would that form be used to impeach Mr. Shreve's credibility, where those aren't even we don't even know those are his statements. We're not sure where that information came from. And if plaintiff wanted to show where that information came from, plaintiff had months to figure that out and did not do so. Okay, this was at Mr. Shreve's deposition, testimony about the form. Yes, I signed page 1. That's my handwriting. That's me. Page 2 and 3 and 4, I have no idea. This was months before trial. And one other point on that, this challenge to authentication was not made for the first time at trial. In the joint final pretrial order, plaintiff put in the exhibits that they were going to use the incident report, and there's an asterisk next to it, and the asterisk signifies down below that defendant is going to challenge the admissibility of that document. That's in the joint final pretrial order.
When was that submitted?
I have there were 2 of them. I have the amended joint final pretrial order here. If you'd like to see it, I'd be happy to.
Oh, you could just tell
Okay.
us.
This was filed on March 6, 2023. It was the amended joint final pretrial order that the parties put together.
We have the register of actions, so
Okay.
that helps. I'll just be able to go back and look at that.
And then it is on page 4 at the very top, defendant's incident report. There's an asterisk there. And then down below, the asterisk says that defendant's going to challenge the admissibility of it.
Thanks.
Yeah. But let's just accept, for the sake of argument, that Judge Hubbard was wrong, that this was such a unreasonable decision, it would constitute abuse of discretion. This verdict was unanimous. It was 8-0. They only answered one question. Was Trinity negligent? Answer was no. They didn't move on to question 2, which was sudden emergency doctrine. They didn't get to causation, damages, anything. They just simply said, no, this was not negligent. He was driving 2 to 3 miles an hour. He might have saw a person walk across the parking lot or reported an incident report. It was an animal. Is that going to change an 8-0 verdict and flip it to 0-8, and all of a sudden they're going to answer question 1? Yes, absolutely not. Very few pieces of evidence are that powerful. That could be outcome determinative on the question of negligence. And here this form kind of nibbles around the edges, whether it was a person or an animal, is not really going to change things. It was also cumulative. Mrs. Zavala testified that Mr. Shreve was driving fast. He couldn't see at night. He was erratic. She was telling him to slow down. She testified to all of these things. And that this form is not going to substantiate that. It was cumulative of what she had already testified to. And Mr. Shreve's testimony was consistent. He was going to 2-3 miles an hour. He was in a parking lot. He tapped on his brakes to come to a stop because something crossed his path. Let me see. Another point of dispute what is the idea that this moves on to issue number 2 about the inability of Mrs. Zavala to testify about her injuries or to introduce her medical records. Plaintiff does have an obligation under MRE 103 to make an offer of proof on the medical records. That was never done. That issue is not preserved. That was not requested in the trial court. No offer of proof was made. That's made for the first time on appeal. Even more importantly, Mrs. Zavala testified not once, but twice about her injuries. The first time Mrs. Zavala testified about injuries, there was no objection. Trial counsel let it go. The second time trial counsel did object. So the first time Mrs. Zavala testified about her injuries, and again, Judge Hubbard was correct to keep that evidence out. Her claims had been dismissed. They weren't in dispute. And it would have been an error to let the jury hear about a non-plaintiff being injured in this accident as opposed to the actual plaintiff was making a claim. But Mrs. Zavala did testify about her injuries, and it was not all objected to. At page 9 on March 7, 2023, Mrs. Zavala's testimony, he was going fast. I think he got mad at me. I aggravated him. Again, she says, so I think he got mad. He started going fast. But I screamed and I was crying until I got home. That's her injury. And I was hurting, testifying about her injury again. I couldn't take my groceries up, testifying about Mrs. Zavala's injuries. I left them there until I could call my daughter to come and take them up for me. Mrs. Zavala testified about her injuries. That was not objected to. The jury heard all that. Moments later, 2 pages later, actually, the jury heard it again. And this time, defense counsel did get up. And Mrs. Zavala said, I start screaming, my knee hit, my mouth was busted, my teeth were loose. So that could be 5 or 10 miles away, is what she said. That time, it was objected to. And the judge told the jury to disregard the testimony. But one time it was not. One other thing that's striking about the trial transcripts here is that negligence was an afterthought. The parties fought tooth and nail on causation, pre-existing injuries, damages. Mr. Zavala had cerebral palsy and diabetes. Those conditions were so bad that he lost vision in one of his eyes already before this incident. And the fight at trial was whether him banging his head when Mr. Shreve slowed down caused him to lose vision in the left eye, or if that was part of his cerebral palsy and his diabetes conditions.
Well, your client was essentially arguing at 2 to 3 miles an hour it wasn't possible to cause any injury, let alone the injury they were claiming, right?
Correct. There was going 2 to 3 miles an hour, hit his brakes. Mr. Zavala says he banged, hurt my eye, is what his testimony came through. Ms. Zavala said the same thing.
So considering that, shouldn't the plaintiff have been allowed to rebut that testimony with evidence that she in fact was injured? And if you're essentially saying, well, he was going so slow, nobody could be injured, shouldn't that have opened the door to the plaintiff being able to put in evidence of her injuries? And of course, she was foreclosed from doing that because of the order on the motion in limine.
That would have confused the jury. That could have misled the jury into thinking, well, if she banged her knee, therefore Mr. Zavala lost vision in his eye, that would have caused all sorts of problems. Her claims were no longer in dispute. She did have a claim. It was dismissed.
Well, I'm not talking about her claim.
Yeah.
I'm saying if on the one hand, your client is saying the driver was going so slow that nobody could have been injured, shouldn't she have been able to step in and say, well, wait, you're opening the door to the fact that I got injured. Obviously, he was going fast enough that I got injured, and here's the evidence of that. In other words, wasn't it an abuse of discretion for the trial court to exclude that evidence?
Well, Mr. Shreve didn't testify about Mr. Zavala suffering an injury or not suffering an injury. He just testified.
No, I'm talking about, I might have misunderstood you earlier, but I thought that was the argument that counsel for your client made at trial, that he was going so slow that it couldn't have injured anybody.
Okay, so this being an auto accident, any injury is not going to meet the threshold. And that argument was made at trial that he didn't meet the serious impairment threshold because this was going to happen to his left eye, just happened to his right eye based on cerebral palsy and diabetes. Mr. Shreve did not offer opinion testimony or fact testimony about whether either of them were injured. He didn't open that door. But let's say he did. Let's say there was testimony from Mr. Shreve. Nobody was hurt. They were fine. They're all making it up. Let's just say he did testify that. Ms. Zavala testified about it anyway. Once unobjected to, that the jury was allowed to consider.
Can't unring the bell, right?
Well, so the first time there was no attempt to unring it. Trial counsel let that go forward. The second time, she got even more extreme. My teeth were loose, all those kinds of things. That would be a difficult bell to unring. And the judge simply disregarded that, but the jury heard it. Yeah, that's a tough bell to unring. But again, they were focusing so much at oral argument and in the briefing on negligence because that's how the jury decided this case. But that's not what this trial was about. If you go to the trial transcript, this trial was about pre-existing injuries. Was he going to lose vision in his left eye anyway, just as he did in his right eye? There were no issues. The issue with his left eye didn't pop up until 6 months after this incident when he started seeing floaters. The testimony at trial, and it's not on the transcript because the court reporter didn't transcribe everything from the doctors. So it looks like there's only a few witnesses who testified here, but doctor after doctor after doctor testified about pre-existing injuries. His treater, defendants had expert witnesses testify as well. Plaintiff's closing argument, this is not a perfect metric because we don't know how long the closing argument was, but during closing argument, plaintiff spent 2 pages total on negligence to get the jury to find defendant was negligent. 24 pages covered causation and damages. That's what this case was about. Negligence was an afterthought, essentially, and the jury didn't agree. And I will agree 100% with Mr. DeGralis' comments earlier about all of the different words that the jury heard about Mr. Shreve's negligence. Mr. Shreve said I was going 2 to 3 miles an hour. Mrs. Zavala didn't say he was going 2 to 3 miles an hour. She said he was peeling out. He started going fast. Page 10, he was going very fast. Page 13, he was driving too fast. Page 12, Mrs. Zavala said he made an abrupt stop. At page 13, she told the jury Mr. Shreve couldn't see at night. At page 12, she disputed his view that there was an animal or a person in the road. She said that there was an island in the parking lot with a sign. He was trying to avoid that and he couldn't see at night. And that's what this came from. The jury heard all of that and the jury rejected it. I also agree with Mr. DeGralis when he said the jury heard 2 distinct theories of negligence. I agree. The jury picked one over the other. And this is a little bit of the soapbox moment, but I've been a lawyer for 22 years. And the pace of jury trials now is unlike any other time since I've been a lawyer on the civil side. Cases are being tried left and right. And Mrs. Zavala got her day in court. Her case was dismissed by Judge Hubbard, Court of Appeals reversed, sent it back down. She got her day in court. And if what happened here, these even best case scenario 2 close calls on evidentiary issues are going to be enough to overturn trial results, no case will ever be final. And you will be seeing every single disgruntled litigant, and there are a lot of them out there, it's tough to find compromise in our society generally, and it's happening in the jury room too. The verdicts all seem to either be no cause like this or a nuclear verdict. And someone's mad every single time it happens, and these appeals are coming left and right from these trial outcomes. And if this is going to be reversible rulings of a trial judge under abuse of discretion standard, as well as a substantial justice, then no case will ever be final. And every disgruntled litigant will be coming here getting a new trial based on the opinion in this case. Unless the panel has further questions, I'll rest on my brief.
No questions.
Thank you very much.
A brief rebuttal. My soapbox, I'll start on it too. I've been a lawyer for 12 years. I've tried cases. I've been no cause plenty. I've won a few of them as well. This is the first one that I've appealed. And the reason why, no cause that I've appealed, and the reason why I appealed is because respectfully to the trial court, I felt like one of my hands was tied behind my back. We had 2 competing versions of events. One of them had corroborating evidence, and the jury was improperly not allowed to hear that corroboration of my client's credibility. So when the jury's job to assess credibility, the jury didn't have the tools that were right there for it to consider. Similarly, the version of Mr. Shreve, ripe for impeachment and cross-examination, much more vigorous cross-examination than was permitted at trial. Because my hand was tied behind my back, I could not use the form. It's not a perfect piece of evidence. I understand that, but it's enough for a jury to consider what evidence about Mr. Shreve's credibility existed, and the jury wasn't able to do that. I don't think this is opening a floodgate to every aggrieved litigant. I think this is exactly why the Court of Appeals exists, for cooler heads to look at the evidence that the jury, in my opinion, should have considered. And my sincere hope is that the jury will get a chance to consider that evidence. And then thereafter, if a no cause follows, you won't see me again, because I was able to try the case that should have been tried the first time. Thank you very much.
Thank you.
Thank you. Thank you. The case is submitted. The next case on our docket is actually, oh, no, do you want it? Okay. Okay. Actually, before we call the next case, which is two consolidated cases, we're going to take a quick break now. And then we'll be back on the bench in a couple minutes. The parties may be seated for the next case if you like. Thank you to the parties for indulging us. You can step up to the podium. I'm just going to go ahead.
Your Honor, I'm not endorsed for oral argument. I'm just here to listen.
Thank you for stepping up. I'm going to call two cases because these are consolidated. Both of them are case 17. First is case number 367494, Samuel Torkow versus Michael Thomas Fox. And the second, also case number 17, 367512, Encompass Indemnity Company versus Michael Fox. So we'll start with, it looks like, Mr. Cafferty.
No.
Oh, no, you're not. If you could just step up to the podium and just make your appearance on the record.
Good afternoon, Your Honors. Michael Cafferty, P36613, on behalf of Mr. Fox. I'm not endorsed for oral argument, but if you have any questions for me, I'd be happy to answer them.
Thank you very much, Mr. Cafferty. Counsel?
Good afternoon, Your Honor.
Solidly afternoon, yep.
May it please the court, William Parker on behalf of Encompass Indemnity Counsel. Judge Wallace, congratulations. It's good to see you again.
Thanks.
So I'm going to try and be relatively brief and for the most part just rely on the briefing in this matter. I just want to point out a few things. There's a lot of discussion in plaintiff's brief about domicile. This case has nothing to do with domicile. This case has to do with the garaging location of the vehicles and the risk in Encompass accepted with regard to that garaging location. There's also a lot in plaintiff's brief about that both Mr. Fox and his parents testified about where he was living. I beg the court to look directly at the parents' testimony because it's at best inspecific about when he lived with them and when he didn't. The evidence in this case is the evidence that Mr. Fox himself considered himself living at the Oak Park address is overwhelming. He changed his driver's license to the Oak Park address 21 months before.
Sorry, I just want to clarify. You said this wasn't about domicile, but it sounds like you're going into domicile and kind of leaving the world of garaging.
Well, but so the testimony is that that's where his vehicles were, where he was residing. So I'm not going to talk about workmen or those types of cases. I'm just going to talk about where he was and where his vehicles were, where he was living. So 21 months before the accident, he changed his driver's license with the Secretary of State to the Oak Park address. He sent an email to the suite agency 16 months before the accident indicating he lived at the Oak Park address. He registered his GMC Sierra in February of 2018, 10 months before the accident, to the Oak Park address. Then 7 months before the accident, in May of 2018, he purchased an F-150 and on the leasing application noted his address as the Oak Park address. There is no question that the evidence in this case establishes that he was living at the Oak Park address. There's a lot in plaintiff's brief about whether or not the renewal was a new contract. The renewal, as indicated in our brief, did indicate that it was amended, and under the applicable case law, if there's an amendment to the insurance policy, it constitutes a new contract. I would further submit to the court that when Mr. Fox added the F-150 to the policy in May of 2018, that had to constitute a new contract because a new vehicle was added to it. If it wasn't a new contract, anyone at any time could add a vehicle to the contract, make up the craziest lies about it to get the lowest rate possible, and there would be nothing the insurance company could do about it. So it's clearly a new contract and clearly subject to rescission. Additionally, plaintiff repeatedly indicates that the knowledge that the suite agency, well, let me say this, there is no evidence in this record that Mr. Fox ever reported it to either Encompass nor the suite agency that he had officially moved. There's evidence that he had requested homeowners quotes and various other things, but no evidence where he called up and reported, I have moved to Oak Park. Plaintiff repeatedly says that even if suite did have the knowledge that he had moved, that it's imputed to Encompass. Plaintiff clearly ignores the case law on this point, that a independent insurance agent is an agent of the insured, not the insurance company. There's no question in this case, that's what we have here. Therefore, the knowledge of Sweet, if they did have any, is not imputed to Encompass. I'll answer any questions if the court has any. Thank you.
Yeah.
Thank you.
Good afternoon. May it please the court, Paul Wilk Jr. on behalf of Eppley Sweet Insurance Agency. As brother counsel, I'll also be brief and mostly rely on our briefing. In his briefing, appellant argues that the sua sponte dismissal of Sweet Insurance Agency violated his due process rights. He states that no analysis was performed of this third-party claim, and he was not given an opportunity to be heard regarding the elements of that claim. So when you look at that claim, against Sweet Insurance, it's one of negligence, and appellant alleges that Sweet knew he was not living in his parents' home and failed to provide him with the proper coverage because he had moved. So in order to assert this claim, appellant needs to prove that Sweet actually had knowledge that he moved, and as brother counsel said, I don't think the record shows that. But as far as due process on this knowledge issue, it's been extensively litigated. Appellant has relied on the same set of facts, and I think 5 briefs now. It's the first set of motions for summary, then a motion for reconsideration, the first appeal, response to the second motion for summary, second motion for reconsideration, and now this appeal. Appellant pretty much only relies on his own contradictory testimony saying Miss Lacasse of Sweet Insurance she knew where I was living. He doesn't offer any evidence of when he told her or when he allegedly gave her this information.
His testimony isn't enough to create a question of fact.
I don't think so in this case because it's so irreconcilably contradicted by the rest of the record. Mr. Fox relies on later in his deposition, talks about how he was talking to Miss Lacasse about insurance for himself, and we have those emails and it's all potential. He says, I'm looking at a house, or he says, I'm buying a house, and in parentheses says looking, and asks if Sweet does homeowners insurance. And then he talks later about upgrading his auto coverage because of a new job, and he upgraded that on his parents' policy, and that was throughout 2018, I think confirmed in December of 2018, just before the accident, when Ms. Lacasse sent a new certificate of insurance with his parents' address on it, and no one objected. His parents never informed Sweet Insurance that their son moved out, and Mr. Fox never informed that he never affirmatively said, I have moved out, I need new insurance. He may have mentioned he was thinking about it. He was asking about potential renters insurance, but none of that insurance was purchased through Sweet. That was done through an outside agency or maybe on his own. I think it was through AAA or Farm Bureau, but I'm not sure. That was not through Sweet. Besides those emails and the certificates of insurance, Mr. Fox's girlfriend also testified he had been living there since January of 2018. He was added to her lease. So he had plenty of opportunity to let Ms. Lacasse know in their conversations. He never firmly said anything about that. So, like I said, that issue has been litigated. I think that all the facts have remained the same throughout this. So, the idea that Mr. Fox did not have opportunity to dispute these facts and this knowledge issue is incorrect. Even in his current appeal, he still relies on the same uncorroborated testimony. So sort of just to tie it all together, I think it's clearly litigated. Mr. Fox has filed 5 separate briefs. The only evidence is his testimony, which, it just doesn't, there's not a clear timeline. I think he's arguing 2 separate things. He's saying, I was kind of living with my parents. And then when it comes to the claims against Sweet, he's saying, no, I actually moved out and I told everyone I moved out. I think his testimony is just completely contradictory. And I think that he had plenty of opportunity to dispute that, and his due process was not infringed upon by the sua sponte dismissal. So we just ask that this court affirm that decision.
Thank you. Any questions from the panel?
Was Lacoste deposed?
I don't believe she was deposed. She prepared an affidavit that was attached.
Thanks.
Thank you.
Thank you very much.
Have a great day.
Thanks.
Thank you.
Thank you. This
Thank
case
you.
will be submitted. Now calling case number 18-368-287, Michael Alexander versus State Farm Mutual Automobile Insurance Company. And it looks like we have one side endorsed for argument. You may
I believe
proceed.
that's correct, Your Honor.
Okay.
Good afternoon, Your Honors. Chris Rossi appearing on behalf of the defendant, the estate of Robert Grant Williams. I think we've pretty much clarified the issues pretty well in the briefing. I'll just try to hit a couple points, in particular, address some of the arguments made by the plaintiff appellee in this case. Starting with the relation back doctrine. I mean, I think the doctrine is pretty well known and pretty clear that it applies to claims and not newly added parties. And so in this particular case, plaintiff never sued my client, the estate, within the time permitted within the statute of limitations for a negligence claim arising out of a motor vehicle accident. Instead, plaintiff sued a deceased person. And the idea that an amended complaint filed, I believe it was filed April 16th of 2023. So that's 2 months, more than 2 months after the statute of limitations ran on February 6th, 2023. That amended complaint is the vehicle with which the plaintiff would have acquired jurisdiction over my client, the estate. And they did eventually, I suppose, acquire jurisdiction when that complaint was served on July 13, 2023, upon the personal representative of the estate, more than 5 years, or excuse me, more than 5 months after the statute of limitations had run as to the claims. And plaintiff makes an argument in their brief that the joinder rule, MCR 2.206, applies to allow or facilitate this idea that, well, we might have sued a deceased person, but now we've got the estate here 5 months later, court. It should all relate back. It just simply doesn't. The case law is so clear. Even the cases relied upon by the plaintiff are clear that the relation back doctrine applies to claims and not parties. Another point I'd make is capacity to be sued. I mean, you kind of take it for granted. I enjoy the lawyers talking about how long they've been practicing law, and I've been doing it a little bit myself for a few years. And you really take for granted who can we sue? A person, a corporation, a governmental entity. Okay, let's look at a person. And in the court rule MCR 2.204C, capacity to be sued says, of course, a natural person. And I thought it was kind of obvious, of course, but it was, we all know within the law, assuming it's obvious is usually a mistake. But in this case, a natural person is a human being, right? And a human being is defined as something that exists. And so we can't have a lawsuit where the party that's allegedly a party to the case is simply dead. And that dovetails with MCR 2.202. I think the rule that the trial court improperly relied upon, that rule does not facilitate suing a deceased party and then later adding the estate. Instead, that court rule is so clear, it states if a party dies. And I would point out if a party, so that would be a party already who the court has obtained jurisdiction over, and then if they die during the pendency of the action, it does not serve as some mechanism or tolling provision. And if it did, I would point out that MCL 600.5856 conflicts with that idea. That court rule states that if you're going to toll a statute of limitations or rely upon a statute of repose, then you really have to have, of course, two things: service of that complaint on the defendant and jurisdiction acquired over the defendant. Neither of those occurred here within the time frame for the applicable statute of limitations, and therefore
that didn't occur until July 13th of 2023, right?
That's correct, Judge Wallace. Yeah, and so there's really no basis. The trial court erred here in trying to find a mechanism to allow this to go forward. And the reality is there's no basis to toll that statute of limitations when there was no jurisdiction and no service upon my client, who wasn't even added as a party at that time. I would also direct the court to Potter versus Devine, unpublished opinion. I understand that, but that case, I mean, it really sets forth a lot of the similar issues that we're presented with here. And I would just note, from Potter, a deceased person cannot be sued. A deceased person cannot participate in litigation. Again, things that I think we take for granted, but the law is so clear here. And I think that I'll just wrap up and say, I think the trial court felt that, well, maybe this is like a technicality. And it's not a technicality. For those of us who practice in this area, there is a 3-year statute of limitations. We all know how important it is to get that party that you want to sue sued with you want your complaint filed, and you also want to serve that party and get jurisdiction over that party within the time frame allowed. And if you don't have jurisdiction over a party, you really have nothing. You really have nothing here. And so we would ask that the court reverse the trial court. I'm happy to answer any questions. All right. Thank you very much.
Thank
Appreciate
you.
the time.
Thank you very
Good
much.
to see you too, Judge Wallace.
Say hi to your
Congrats.
wife for me.
Absolutely. You too. Thanks.
This case is submitted.
Kind of weird to see you and Mr. Parker here on the same day.
Right. Yeah.
Who both used to work.
We're in the trenches
Yeah.
quite a bit together.
We'll begin our 11 o'clock docket next at 12:19. Now calling case number 19-365-854, Kenya Moore versus Lavonda Hopkins.
Good afternoon, Your Honors. I'm Richard Brewer, P31124, and I represent the plaintiff appellant Kenya Moore. This is a automobile accident negligence claim for non-economic damages, which makes serious impairment an issue in the case. This appeal arises from the fact that on September 7th of 2022, Judge Hubbard granted a C-10 motion for summary disposition on the issue of serious impairment. And by doing so, she precluded the jury from hearing the evidence on the serious impairment. Now, the sole question that we really have to deal with, cutting to the chase, is was there proffered sufficient evidence to establish that Ms. Moore suffered an injury in this accident, which was objectively manifested and was of sufficient severity to affect the way she lives her normal life? I'm not going to talk about the law of serious impairment. That's a pretty well-tilled field, and I'm not going to dip my plow into it. Your Honors are certainly sufficiently aware of what the requirements are for serious impairment. But what I want to concentrate on is what evidence Judge Hubbard had, or potentially admissible evidence Judge Hubbard had at the time that she denied my client her day in court. The first thing we have is the deposition testimony of my client, wherein my client testified under oath that she sustained injury in this accident, which caused her pain and tenderness in the neck, the shoulder, the low back, and the knees. The evidence that Judge Hubbard had before her, again, based upon my client's testimony, was that these injuries, these subjective complaints, if you were, prevented her from living her normal life. She couldn't garden, she couldn't pick up the grandkids, she couldn't do any number of things that are detailed in the deposition transcript, which we have attached to our brief. The second thing that Judge Hubbard had before her were IMEs of the neck and the low back and the shoulder, which showed objective evidence of injury. I don't think anyone realistically argues that an MRI finding is not objective. It certainly is. The third thing that Judge Hubbard had before her was the report of the defense IME, Dr. Meisner, I think it is. And Dr. Meisner was asked this question: does the claimant have objective findings? If so, please explain, are the subjective complaints supported by the objective findings? Please elaborate. And this is what he said. Yes. Please see above. Some of the objective complaints are supported by objective findings, namely in areas where she exhibited tenderness. Where did she exhibit tenderness? Neck, shoulder, low back. He takes issue with the knee, but one serious impairment is sufficient to meet the requirements of serious impairment in a motor vehicle accident case. So the question that then is, did Judge Hubbard improperly take from the jury their ability to weigh the credibility of this evidence before her that she had available to her? And the answer, I think, is yes. It's up to the jury to decide whether they believe what the defense own expert said in his report. And the fact that he didn't say this under oath is really immaterial, because the standard is evidence that may be admissible. And certainly his testimony as a designated expert on behalf of the defense would be subject to deposition or live court testimony and would be ultimately admissible evidence. And it would be hard for him to contradict what he wrote in his IME report. Therefore, I'll get right to the point. Therefore, the judge usurped the duty of the jury to weigh the credibility of the evidence that was before them, or could have been before them, but she denied them that opportunity, and she shouldn't have done it. C-10 motion doesn't test the credibility of the evidence. All it tests is whether there is sufficient admissible evidence so that a reasonable juror could find in favor of the plaintiff. And in this case, I submit that there was sufficient evidence to allow a jury to find in her favor. Thank you.
Thank you. You have time for rebuttal.
Good afternoon again. May it please the court, William Parker on behalf of Ms. Hopkins. Again, for the most part, I'm going to rely on my brief, but I do want to discuss a few points here. Judge Hubbard granted this motion for summary disposition on the basis of that there was no objective manifestation of injury that meets the definition under 3135. Counsel noted that you have plaintiff's testimony that's insufficient to meet that burden. It's got to be something that someone else can perceive other than the plaintiff. The MRIs, while they did show findings, what we do, we see case after case after case after case where there's all kinds of findings on MRIs. Doesn't mean it has anything to do with a motor vehicle accident. And plaintiff has presented nothing to the trial court nor this court to indicate that the findings on the MRI were related to the accident. And the way the MRIs are written, it refers to what appears to be degenerative changes. So plaintiff, the MRIs do not help plaintiff's case. That leaves us with Dr. Meisner's report. Dr. Meisner is an internist. I'm not sure this makes any different, but he's not my expert. He was an expert on the PIP end of the case, but nevertheless, that's what's before the court. Let's really look at what he said. I'm going to read what counsel already read. Does the complainant have objective findings? Question mark. If yes, please explain. Are the subjective complaints supported by the objective findings? Please elaborate. Yes, please see above. Some of the subjective complaints are supported by objective findings, namely in the areas where she exhibited tenderness. Nowhere does no one took Dr. Meisner's deposition to find out what the heck he was talking about. He talks about objective findings with regard to tenderness, which is clearly a subjective issue. It's pain, right? So that's certainly in specific, but more importantly, nowhere does Dr. Meisner say that those findings are related to the motor vehicle accident. Nothing was ever presented to the court to tie in any of the findings on any of the medical records to the automobile accident. And therefore, Judge Hubbard granted the motion and correctly granted the motion, and we'd ask that you affirm her ruling.
Thank you. Thank you.
As my client testified under oath that before this accident, she did not suffer the quote subjective complaints that she suffered from after the accident. She sought immediate medical attention. Those are in the medical records. She identified the day of the accident as the date of the onset of these conditions. She complained that her neck and shoulder and back pain prevented her from living her normal life. Dr. Meisner was asked, are these subjective complaints supported by objective manifestation? And he said, yes. The subjective complaints establish that a relationship between the motor vehicle accident and the subjective complaints, i.e. temporally, it happened after the accident. We do not have any pre-accident MRIs or x-rays or anything else which show these same findings that are shown on the post-accident MRIs, which, by the way, were only taken a couple of months after the accident. This wasn't a long time. But the point is this: Michigan still believes that we can have aggravation of pre-existing conditions. So something that was argued and I didn't touch upon earlier is that her problems predated this accident. Some of them did, no question. But her testimony clearly establishes that she suffered aggravation of pre-existing conditions and possibly new injuries. Dr. Meisner says that these complaints are supported by objective manifestations, i.e. the MRIs. Any questions?
No, but thank you.
Thank you very much.
Thank you.
The case will be submitted. Next, we'll call case number 20, docket number 367800 in Ray Frankfurt Estate. And it looks like both sides are have argument today.
Good afternoon, Your Honors. My name is Andrew Mayoris. I represent the appellant, the brother of the decedent, Michael Frankfurt. And I'm going to try not to reiterate what's been in the briefs. I do want to elaborate on a few key points. I understand Your Honors are familiar with the materials in our briefs and have had a long morning already. But there's a couple key points I want to illustrate, starting with the probate court here made it clear here. And the error was in applying the wrong legal standard. Judge O'Brien, in his lengthy oral ruling set forth in the transcript dated 8/31 of 2023, spent a lot of times debating what a document meant to be a will. What is a will? And he framed the issue ultimately as whether the decedent intended this document to control a disposition of his property at death. Page 27 of that transcript. This misses the standard. And this is the standard that has been in existence in Michigan going back to the 1800s. And it's set forth most directly in the Horton case, which states not only does a document have to have this intent, but, quote, it must be final in nature. That is, mere drafts or a mere unexecuted intention to leave by will is of no effect. The judge, in our case, in his ruling on page 34 to 35 of the transcript, found it didn't get rid of everything. I didn't dispose of everything. He was not finished, just like he told his dear friend Michelle. If he was not finished with his will, the document cannot be final in nature. That is the essence of this matter. I want to spend a little bit of time on public policy, Your Honor, because it may not be readily apparent that this case actually does have bigger public policy ramifications beyond merely the parties involved in this case. We know that Michigan has a long-standing public policy, as with other states, for wills to have a certain level of formality. And when Epic came along in 2000, It's specifically stated in MCL 700.1203, it does not replace common law principles, it supplements them. 700.2502 sets forth those minimum qualifications for a document to have the formalities requisite to be a will. And there's important public policy reasons for that. A, the decedent's not alive to ask questions of, unlike in a contract case or a tort case. B, many cases involved whether the testator had sound mind or was subject to undue influence, and the less formalities that exist for the documents, the more that's called into question. It's not an issue in this case, but again, I'm discussing public policy. But three, and perhaps most importantly for this case, people change their minds. When my children were little, if one of them did something wrong, I may say, you've lost your phone for a month. My wife may come to me the next day when I've calmed down and say, did you really mean a month? No, I didn't mean a month. Let's give her back her phone in a day or two. People can change their minds. That's why this finality requirement is so important. As the Horton case noted, which involved a suicide note, the decedent at the end typed his name, his full name, which the court said this added an air of solemnity to the process. The problem with the probate court's ruling is that it allows the exception of 2503 to swallow the rule. And if this is allowed to stand, even if it's affirmed on an unpublished basis, probate attorneys will use this case to champion any document whatsoever as a testamentary document. The finality provision will be gone. The formalities will be completely irrelevant. A simple email or a text from one person to another, maybe a cocktail napkin. If I die, I want you to get my house. That will be enough under this case. At least arguably, the floodgates will be open. And the reporter's commentary, which we've cited extensively in our brief, is very important on this issue. It warns against this very point and notes that 2503, the exception to the rule, is to excuse a harmless error, right? If somebody maybe has one witness instead of two, if a lay person doing a holographic will maybe doesn't sign at the end or it has a minor inconsistency, that's what this rule is intended for. It's not to allow the document that exists in this case to be a will. And we've cited several relevant cases in our brief. I'm not going to reiterate all those, other than I do want to point to the New Jersey case of McCool, which was cited favorably in the Attia case, which stated there that a similar document was found to be a, quote, work in progress subject to reasonable revisions and fine tuning, i.e. not final, a mere draft. That is unquestionably what we have here. The judge selected 2 pages out of a much larger packet of documents submitted by the appellee. And even though these were a list of 15 items that are clearly a to-do list, need this, need that, I need to sell the house, I need the tax ID number, I will make a list. This is not a final document. There's no way it can be. We're not challenging the credibility of witnesses. They testified to what they were told. But regardless of what they were told, you cannot put lipstick on a pig and change it from still being a pig. The document.
Can you speak to how your case is distinguished from Attia?
Absolutely. Attia was a very limited holding, Your Honor. Attia dealt with, on summary judgment, summary disposition, whether an unsigned will could ever qualify to be a valid testamentary document. The court did not find that that document was testamentary. They said it's a question of fact. And in that case, the decedent died very suddenly before having a chance to sign the document. So it's a question of fact. I don't quibble with Attia. It's binding law. That's not what we have here. We have a gentleman who went to an attorney 7 years before he died, had draft documents prepared. The proponent offered those documents as part of the package. But the court said, I'm not counting those documents. I'm counting 2 pages from your packet. They've conceded in their appellate brief the unsigned draft documents don't count. Okay, so that's what difference is this case from Attia. And I'd like to end on this, Your Honors. 2503, again, recognizing the importance of the formalities and not allowing the exception to swallow the rule, states the proponent of the document has to satisfy by clear and convincing evidence that the document's intended. As we indicate in the close of our principal brief, the N. Ray Martin case, to satisfy that test, the evidence must be so clear, direct, and weighty and convincing so as to enable the trial court to come to a clear conviction without hesitancy of the truth of the precise facts at issue. The judge, again, in his own words, in the transcript that I cited before, stated, I went back and forth. I was going to say, no, it's not a will. I was going to say, you got to go. Then I was going to say, yes, it was a will. I'm going to rule for you. He didn't have no hesitancy. And that's even applying the wrong standard, as I stated before. But again, if you look at the document on its face, these 2 pages, there's no way to square this document with the documents in the unpublished cases, in particular the Reed case, which we discussed at some length in our brief, which actually was a full holographic will, but was still rejected because the document appears to be Reed's attempt to organize her thoughts and determine how to divide her estate. No finality. And that's the fatal flaw here. There's no finality in this document. And that's reflected in his words to his dear friend, who is not a party to this case, a few weeks before he died, when he turned to her and said, I did not finish my will. And again, the judge didn't reject that as being not credible. He cited that in his testimony, evidencing his failure to apply the clear standard that does apply. Thank you, Your Honor. I would ask to reserve a few minutes for rebuttal if I have time.
You do have time. Thank you.
Thank you. Your Honor, it's Drew Carnoth on behalf of Appellee Courtney Foltz, the petitioner in the matter. I guess what I'd like to start with is that the aspect of Horton that counsel and I seem to disagree about is that Horton suggests that any document, any written statement could be considered a will under 2503. That's what Horton specifically is finding here. And that the attachment to that is that you have to establish by clear and convincing evidence that the document itself was intended to be the will. So we get back into the factual issue that the trier of fact on the trial court level went through very, very deliberately. There was actually 2 different hearings that took place for the closing. And at one point, the court interrupted the closing arguments to try and investigate further into this issue. When counsel says that the trial court was waffling or suggested waffling about whether this was a will or not a will, he does start in that vein in his order that, that the transcription of his ultimate ruling, he starts in that vein, but he very quickly suggests that it was because of his preconceived notions of what a will is, and that this document doesn't seem to fit within his preconceived notions from being a probate judge for the last 14 some years, right? He had to reevaluate his preconceived notions, and that is because of the law that he was very clearly identifying in Re Attia and in Re Horton, that the 2 cases that counsel and I both agree are the enshrinement of the interpretation of 2503. I'd just like to point out something from the court's ruling. This is in the August 31st, 2023. This is the trial court's final opinion of the matter. But Courtney did absolutely identify it as his writing. And when he's making this list about what he wants to happen with this property, he then goes into talking about his death and what to do after he dies. This is clearly all one document, clearly intended to be read after he died. I mean, that's what all of this tells me. He says April to get the house. That was his stepdaughter. Again, he's not talking about giving her the house today. He says April 2. He's talking about the future right after he talked about his death.
The testimony of the petitioner's witnesses are all consistent. We know that David wanted what we know what David wanted to do. Is there a writing that shows? I don't think it would meet any legal standard knowing what David wanted to do after he died. Beyond a reasonable doubt, got it. Clear and convincing evidence, you got it. He told everybody what he wanted. He wrote down what he wanted. The lawyer put into writing what he wanted. It's all consistent. And these writings, document, what have you, are in his writing. This is the document that he intended as he told Courtney to control the disposition of his assets after death. But I find that these 2 pages, paragraph 1 through, I'm inserting paragraph 1 through 15 by clear and convincing evidence are in fact a writing referenced in 2503, a writing or document that David intended to be, quote, will, unquote. In other words, David, in the language of the statute, and I believe this is what I discovered when I'm trying to make effective, that he states in 1201B that this was his intent in the distribution of his property. This writing here, 1 through 15, this is how he wanted it done. The judge was not, the trial court, the determiner of the facts in this matter was not wishy-washy about what he determined. He was very clear that the facts that this document fully encapsulated what Mr. Frankfurt's intent was. That he was very clear how he believed that Horton and Attia applied, and that he used that law to apply to these facts that this document is a writing. And I'd like to go through Horton for just a moment. One of the things in the reply from appellant was that, and I think at its core is that this particular 2 pages document, this doesn't look like a will. This looks like something else. This isn't conventional. This doesn't meet the mark for what we would think of as a testamentary document. I agree. That's what 2503 provides for. And that's what Horton says 2503 provides for. So if you look at the document itself, the 2 pages, paragraphs 1 through 15, that ultimately are what the court determined to be the will. And I will say, just as a side note, I was the attorney at the trial level. With my client, we determined that the packet was found together. So we weren't going to separate the packet to the documents that we thought would be the specific controlling provisions of the will. We wanted to submit everything to be transparent so that the court, that everyone would be clear that this is how we found these documents. This is how we were instructed, where we were instructed to find these documents. But on the document itself, it was determined by the court to be something that was composed after meeting with the attorney. And that the court made that finding on the basis that the starting point is Courtney's name, correct spelling. Courtney in the will itself is spelled, from the draft will from the attorney, is spelled maybe the more conventional way of Courtney. My client, Courtney, is Courtnie. And at the time, she was referred to as by a different last name than what ultimately was her name. So the court found that this document was actually a compilation of his thoughts and notes in writing that existed after he met with the attorney, that he was considering what he wanted to do and writing that down in his handwriting. So when you look at this document, I admit that there are notes and there are things that are not conventional in a will. But if you cross compare that with the beginning part of In Re Estate of Horton, I would just like to go through this for a moment and what the court provides in that matter. This is an individual who, ahead of committing suicide, created a note that said, "Go to my Evernote," something to that effect. Okay, and Evernote being some kind of electronic document storage or something. I'm sorry, I'm not more familiar with Evernote, but the court said this: the document contained apologies and personal sentiments directed to specific individuals, religious comments, requests relating to his funeral arrangements, and many self-deprecating comments. The document also contained a paragraph that said, "Have my uncle go through my stuff, pick out the stuff that belonged to my dad and or grandma and take it. If there's something he doesn't want, feel free to keep it." It's not even clear who the document is being written towards, right? All of my other stuff is yours to do whatever you want with. I do ask that anything you give 10% of money to the church, 50% to my sister Shella, and remaining 40% yours to do whatever you want with. Again, this document is not a clean conventional will that we see from attorneys. It's messy. It's a non-attorney trying to prepare their wishes. That's what Horton determined ultimately, is that this is a reflection of his intent. The Evernote was considered to be a document that was the controlling will under 2503. In reaching that conclusion, the court provided, and I'm actually looking at page 9 of the sorry, it covers from page 9 to 10 in the Lexis. It's I think the published opinion is page 212 to 213, but it says, turning to these facts of this case, we find no error in the probate court's determination that decedent intended for the electronic document in question to constitute his will. In basic terms, a will is said to be a declaration of a man's mind as to the manner in which he would have his property or his estate disposed of after his death. A will not need to be written in a particular form or use any particular words. For example, a letter or other documents such as a deed could constitute a will. Again, totally away from the formalities. However, in order for a document to be considered a will, it must evince testamentary intent, meaning that it must operate to transfer property only when and by reason of the death of the maker. This is an issue that Mr. Mayoris has raised, an issue which the court was very clear on and addressed and indicated in its findings that this document was not precatory, but determined to be a specific final disposition. Moreover, the document must be final in nature, and mere drafts or mere unexecuted intention to leave a will is of no effect. Again, to Mr. Mayoris's point, he's suggesting that the document we have fits within that category. Ultimately, in deciding whether a person intends a document to constitute a will, the question is whether the person intended the document to govern the posthumous distribution of his or her property. That is a question of fact for the trier of fact, a question that the trial court answered in the affirmative. I would draw the court's attention to footnote 6 of the Horton matter. And in that, discussing the precatory aspect of it, Jones argues, Jones was the original appellant, the mother of the decedent in that matter. Jones argues that language is such, if at all possible was a phrase that the decedent used, is insufficient to demonstrate testamentary intent. The probate court rejected this argument, correctly recognizing that decedent used unequivocal language when he used the phrase, "not my mother," and when he stated to his half-sister, "all of my money is yours." So the court does this internal analysis within the footnotes of what's precatory, what's not precatory, what was intended to be final, and determined very clearly the statements that he's suggesting, the statements that the decedent is suggesting here, home to April, for McKinley, 2 grandkids. He says McKinley, 2 grandkids. That's one of the cottages that was under dispute. He goes through and identifies his funeral wishes, what he wants to have happen, what he makes happen himself. So he did prepay for a cremation at Dreyer. All of these things together, the court determined based on the testimony of the individuals that clearly stated in its uncontroverted testimony that David wanted these things to happen, consistently communicated that he wanted April, his stepdaughter, to have his home, that he wanted the kids to have McKinley, that he wanted, in fact, Courtney testified in her testimony. He told me that I need to make sure that I was prepared to be in charge of these types of things. He told me that my mom was going to inherit the home. She wasn't inheriting any money because he was splitting 70% for the grandkids, 30% for the great grandkids, excuse me. Those are consistent things that we see in this document, paragraphs of 1 through 12, that the court determined to be the will. So I would just ask that the court would affirm the decision. The trial court made very diligent factual findings, reviewed the matter very thoroughly, cross-compared the controlling law of Adia and INRI estate of Horton, and determined that this was the decedent's will under 2503. And I just ask the court to affirm that.
Thank you. Any questions from the panel?
Thank you.
Thank you so much. Any rebuttal?
Briefly, Your Honor.
Sure.
Clearly, Mr. Carnwath and I agree that Horton is the key controlling case here. This is what Horton said that shows that that case is different than ours. Given the surrounding circumstances, although the note was undated, the probate court reasonably concluded that the electronic note was written in anticipation of decedent's imminent death by his own hands. The fact that decedent wrote a note providing for disposition of his property in anticipation of his impending death supports the conclusion that this was a final document to govern the disposition of decedent's property after his death. Mr. Carnwath called these 2 pages a compilation of his thoughts and notes. I agree. The 2-page compilation of thoughts and notes cannot be a will without a finding of finality. Footnote 7 of the same Horton case. We observe that although the electronic note does not contain a handwritten signature, decedent entered the document with the more formal use of his full name, Dwayne F. Horton II, which added an element of solemnity to the document, supporting the conclusion that the document was intended as more than a casual note. Horton also states in a footnote, this is not to say that formalities or lack thereof are irrelevant in a will contest involving 2503. Formalities are considered indicative of intent. Consequently, in adherence to some formalities, or conversely, the extent of departure from formalities can be considered when determining whether a document was intended to be a will. It then cites the commentary from the Uniform Probate Code under this section. The larger the departure from section 2502 formality, the harder it will be to satisfy the court that the instrument reflects the testator's intent. Again, Your Honors, I presume you have. If not, you certainly can look at these 2 pages of 15 thoughts and notes. There's no way to say that this is final. There's an indication of Amanda being age 12, Alyssa age 9, and Autumn age 7. Other notes from the same packet in the record show their dates of birth, put this at around 6-7 years before the decedent died. This was not final. This was not final. This was not done in anticipation of his pending death. Unlike Horton, this is a mere draft. It cannot be final. Any questions, Your Honors?
Just so you know, we've not only read it, but it was the second document in our record after your claim of appeal. So
okay,
we're very familiar with it.
Thank you, Judge. I appreciate it.
Thank you.
No, thank you.
Thank you both. The case will be submitted. Next, I'll call 2 consolidated cases under case number 21. The first is docket number 370776, William Harrison versus Melanie Hollis. Next is docket number 370791, William Harrison versus Melanie Hollis. As of 9 o'clock this morning, both parties are endorsed for oral argument. You may proceed.
Good afternoon. My name is Stephanie Lambert, and I represent the plaintiff appellant, Mr. Harrison, who is present to my left. There are 2 matters before the court in this appeal that I'd like to address, and I'll begin with the issue of the refund under MCL 168-867 subsection 6. That language, as we've stated and we rely upon in our briefs, does not include the words or terms early voting site or absentee voting board. The judiciary is not the appropriate mechanism to amend a statute, and the court cannot add new words or terms to statutes. And I would rely upon King versus Oakland County Prosecutor 303 Mishap 222, where it states that the holding was the legal terms at the time of ratification and when the are clear and unambiguous, leaving no room for the judiciary to interpret and must apply the terms in the statute. This recount took place in 2023, a full year after the proposal in 22. had passed, leaving an entire year for the Michigan legislature to amend or pass new laws to provide for early voting site to uh, require an additional fee. And I would rely upon similar holdings in County of Wayne versus Haithcock, 471 Mish 445, Kane versus Waste Management, 472 Mish 236, Hobart versus Detroit, 17 Mish 246, and Stice versus Liquor Control, 28 Mish App 358. The Michigan election officials correctly stated that elections in Michigan are run at the most lower level of the municipal offices. It's the cities and townships that run and have the constitutional duty and authority to conduct fair and accurate elections in the state of Michigan pursuant to our Constitution and hold the records pursuant to 4165. What the law does not state is that vendors run our elections. In Michigan, 3 vendors can be utilized by clerks, which would be Dominion, Hart, and ES&S, but they are not to run our elections, and nowhere in the Michigan law does it provide for a vendor to run the election. A recount is a check and balance to ensure essentially that the votes were legal votes were properly counted. And legal is the key term. The most important consideration that I don't think any court has considered in Michigan would be attachment E filed in this case, which is the EAC report. And while it has been stated over and over again that any issue with an election is misinformation, this is from the United States Election Assistance Commission. And on page 4, it discloses that the vendor submitted a root cause analysis showing that its source code was erroneous, which resulted in an inaccurate tally of an election. And this is significant because in Michigan, we report and certify our elections based upon electronic results. The only check and balance on a vendor or a machine count would be a hand paper count and an investigation done at the local most level to be a check and balance to make sure that the electronic reporting is accurate. The election process should never be a partisan or political process. And Mr. Harrison wants to make sure every vote in this election counted, regardless of political affiliation. It's not a partisan process. He submitted in his brief affidavits reflecting, and this is very concerning because none of the precedent prior to this case contained early voting. Affidavits from people that had voted but were not reflecting as having voted. So what is the explanation for that? Only an investigation would reveal that. And that would mean at the lower level before an election is certified, a full investigation would have to be conducted looking at paper and all records to make sure that it reconciles pursuant to 4165, and they should be maintained. The court found this issue to be moot. It's not moot because the mootness doctrine states that anything that is likely to reoccur is never moot. And as we know in the 2024 election that just took place, the Secretary of State did a press release that said that there was a malfunction. Well, she used the slang term glitch with the election machines, and that she had to ask the vendor what the explanation for the malfunction would be. So if we have a scenario where malfunctions can happen with vendors, where nowhere in Michigan law does it say that a vendor runs an election, we have to have a check and balance, which would be a recount and an investigation.
Did a recount happen here?
It's Mr. Harrison's position that it did not, because the machines were used to, again, retabulate, which the EAC report in attachment E details why that's problematic. In that situation in Williamston, Tennessee, the clerk.
So there's an EAC report.
Correct.
That you've attached that explains that there was issues with the particular machinery used for the initial vote count and the recount, but the report you have indicates an issue on a single machine or multiple machines in Tennessee.
So in Tennessee, it was a municipality where the clerk did a hand count after the machine count because she suspected something was wrong. She was taking notes throughout the day. She was diligently doing her job. Her hand count did not match the machine count. So she assumed that she counted wrong. So she took the same stack of ballots and put it back through the machine, and the machine count matched the second machine count. So she said, oh, I was wrong, but let me hand count again. So she hand counted again. Her hand count matched her hand count. So her hand counts were all matching, which differed from the machine counts that were all matching. So she involved the Secretary of State, which couldn't answer her questions as to how this could possibly happen. The Secretary of State involved the EAC, which is the federal arm of elections, and the EAC couldn't answer how this could happen. Only the vendor, where there's no transparency, was able to disclose and reported that the root cause analysis was erroneous source code. So that is a problem and would be
Do
unconstitutional.
we have anything to say that the machinery used in this election had an erroneous source code problem?
That's where the investigation needed to take place along with the recount, because yes, that would be attachment G, and the affidavits under attachment C that reflected that many voters were saying that they had voted, yet their vote was not reflected as having counted. So only a full investigation where you reconcile every aspect of the election, because machines are not transparent. When we go to the bank and we pull out cash, the teller runs it through a machine, which tallies it, and then they hand count it in front of you to make sure the hand count matches the machine count. That's the check and balance. So all previous cases that have considered machines for a recount or the statute did not consider what has now been disclosed by the EAC, that there can be erroneous source code. And again, this is not political. We don't know whose vote may or may not have been counted. If you're utilizing that process to conduct a recount, it's essentially just potentially counting errors again, because it's not transparent. That's why it's so important to conduct the investigation on the spot. And that's not moot. That could still be done at this point. Everything has been preserved. And then we would be able to see and actually verify. And the lay definition of recount is to add it up again and investigate what actually happened and how there could possibly be so many affidavits where people are saying that I voted and the system is not reflecting that I actually voted, and I want to know what happened with my vote. I have no idea what their political party is, but no court has been able to consider this EAC disclosure, which took place in March of 22, in conjunction with recounts. And that's what Mr. Harrison is asking of this court. With that, I'd be happy to answer more questions or reserve my time for rebuttal.
I'm just looking at the plain language of MCL 168867, and it's not clear to me where it affords you the right to guide the recount in the manner that your client sees fit. So I understand the desire for the investigation. I understand that the evidence produced of fraud. I understand the apolitical nature of the request, but what I'm concerned about, just given our status as an appellate reviewing court, is where in the statute a petitioner is afforded the right to so intensely guide the recount process.
That's a great question, Your Honor. And it would be our Constitution, it would be the United States Constitution, that every legal vote must count. And that is where it just didn't take place. He asked for an investigation, called for one, and the ballots were simply just put back through the machine. And there was no investigation with regards to the affidavits. So it's not just, so there was the Barrow case, I think the court referred to, which did not consider the EAC report where it had been disclosed there can be erroneous source code that results in inaccurate
So are
tallies.
the individuals who voted claiming that their constitutional rights were violated in this lawsuit?
Yes.
Okay. And so they're plaintiffs in addition to your client?
My client has filed the matter, and he's included And he has standing. And so if there's dilution at all in an election, which it appears there could be here, because there's a number of individuals that have said that they voted and it's not counting. It's not just his one vote that should be considered. It's the fact that there was no investigation conducted. And so while the Barrow case talks about a machine recount, this is a new consideration for this court with regard to the EAC report that we report in Michigan electronically. And the check and balance on that would be a recount. And recounts are expensive. And Mr. Harrison overpaid for a recount and was essentially forced to when he was submitting for one because he wanted it done. There's a short time window to do that. And it's not moot. If it could resolve an issue as to a systemic problem that we could have, where we have a number of individuals that have said they voted and it's not reflected as that they were counted, their vote was counted. If that could resolve any problems in future elections or in this election, it's not moot. And for those reasons, we ask that it be reversed and affirmed on the refund matter. And I would reserve the remaining time.
Okay. You have time for rebuttal.
Yeah.
Okay, just as long as you manage your time.
Yeah, I guess for clarity of the panel, this is a bit procedurally unique in that.
Can you go ahead and put your name on the record?
I'm sorry. Yeah. Chris Trebilcock on behalf of defendant Oakland County Board of Canvassers. I'd like to also note that my client contact, Clerk Brown, is watching the proceedings on YouTube. She intended to be here, but was delayed and unable to get here. But as it turns out, she may have been able to make it. So I say that in jest, obviously. Procedurally, just to note that the Oakland County Board of Commissioners appealed the trial court's decision on reconsideration only, which was only applicable to the fees. It was plaintiff appellee who appealed the entirety of the decision below. However, on appeal, the appellee failed to raise any issue in the questions of fact or statement of questions presented regarding the fees and focused only on the audit. And therefore, we would argue that that argument has been abandoned or waived by the plaintiff appellee. Second, as it pertains to time, I don't anticipate that there will be a time issue, but I just wanted to note that we were both from Oakland County Board of Commissioners, that we are an appellee as well as an appellant. So I don't know if that matters to things. On appeal, there's just big picture here. There's two buckets that are issues at appeal. Issue number one, was the proper fee charged per precinct for the recount on Proposal B in Royal Oak in December of 23? And then the second bucket is there a clear legal duty and a clear legal right to an audit in the way that plaintiff appellees demand that or think it should be done? Those are the two buckets. Before I get into some of the reasons why this court should affirm the trial court's decision on the issues of the audit and affirm in part and reverse in part the decision on the motion for reconsideration, before I get into that, I want to just correct, so we're all on the same page here, on a couple of misstatements of law and fact by plaintiff appellee. First, plaintiff said that there is no statute that says that absentee voting boards are separate precincts under Michigan law. That's just incorrect. As the trial court recognized, MCL 168.569A subparen 2 expressly states, quote, an absent voter counting board is a separate precinct for purposes of this act. Okay, so it's been that way since at least 2012. It's been in every recount I've ever participated in since I think the first recount I did was back in 2004. Absentee County boards are handled as separate precincts, both for counting, for tabulating on election day, and for recount purposes. So that's just a misstatement of law or misunderstanding of law.
Say the MCL site again one more time.
168.569A. Second, this issue about there was no legal recount. Plaintiff admits, and in fact, the law specifically permits under MCL 168.871, allows a recount to be conducted by electronic tabulators, which is exactly what happened here. What you've heard is a bunch of misunderstanding, confusion, or misinformation about how a recount occurs. I just did the only recount that occurred in Michigan in 2024 over in Jackson County under the new statute. And what happens is before you can even run the ballots through a tabulator, they bring over the box, the ballot container box. They bring it over to a tabulator. There's 2 election inspectors there. There's staff from the Board of Canvassers there. There's challengers from either party that can be there. There's observers that are there. They watch. They go through a checklist to determine whether or not the precinct is recountable. What that requires is a visual inspection of the ballot container to make sure the seals match with the poll numbers and the tape from election night, that it matches the statement of counts that the local clerks have given to the county board of canvassers. They go through all that. If they can be recounted, they open the precinct and they look at the poll book and make sure that all the ballot numbers and the ballots issued and the ballots counted all match the tape and the statement of votes. And if they don't, is there an explanation in the poll book as to why it may be out of what we call out of balance, right? They go through all those things. And only when you determine that the ballot or the precinct is recountable, do you run it through a machine or do you do a hand count? There's the affidavit attached in the brief below from Gloria Spann, who's chair of the Oakland County Board of Canvassers, and she testified that they, with other members of the Board of Canvassers, inspected the condition of the ballot boxes, the seals on the ballot boxes, compared the numbers to the seals, numbers listed in the poll books to verify the integrity of the election materials. There is a record of a number of ballots issued in every municipality in this state. And there is a corollary number of votes cast, and they reconcile those when they do a recount and when they do the canvass. That is what the duty of Board of Canvassers is at the county level, and that is what the duty of the Board of Canvassers is at the state level. What you're hearing today is really a rehash of things in 2020 and just based on information. Again, misinformation. I'd show about the misleading attempt here by plaintiff appellees by just citing Exhibit 3 that they talked about, this EAC Elections Assistance Commission report. First of all, the very text of it says it's an isolated incident that occurred in one county in 2021 in October. Nothing about Michigan, nothing about the 2023 November election in Royal Oak. And not only that, they have the audacity to say that somehow this puts a clear legal duty on Oakland County Board of Commissioners to do something different and not exercise their discretion by talking about the EAT testing it's an isolated coding issue, is being implemented by and being identified as being implemented by the manufacturer Dominion Voting Systems. Dominion. Plaintiffs attach an affidavit to their brief on appeal with you guys, noting that the vendor in Oakland County is Hart Voting Systems. It's not even the same voting equipment.
Also, the last paragraph of that report says that the problem was fixed, right?
Yeah, the problem was fixed. This is the election system here, and after all the issues in 2020 that were raised in the public, court clerks clerks across the state have increased visibility by holding public hearings where they test our local equipment and update the codes so that any problems are identified as early as possible. Those are public meetings and noticed by the clerk of Oakland County. If the plaintiff in this case had a problem with the voting tabulators being used in Oakland County or Royal Oak specifically, those issues could have been raised at any point prior to November 23. They were not, and so they cannot be brought here. So again, those are the issues, but getting back, those are just the problems in the misleading statements I find in the argument. I want to go back to just why this court should affirm the lower court's decision on the audit. It's very straightforward. We cited Barrow in our case. I think you can look at even more recent decisions of the Supreme Court, Holiday versus Board of Canvassers. There was a Court of Appeal decision, but the Supreme Court denied review. That was just in 2024, in September of 2024, involving Cornell West nominating petitions. And there, plaintiffs were arguing that the Board of State Canvassers had certain duties to investigate the fraudulent signatures that were submitted. And the court again affirmed that under Michigan statute, there's a clear legal duty to commence an investigation, therefore can be compelled by mandamus, whatever you prefer, but only the discretion in how to carry that out is left to the Board of Canvassers. And that was the rule in Barrow, which existed before this case was filed. It was followed again in Johnson v. Board of Canvassers, 341, Mishap 671, 2022 case I was involved in, involving Perry Johnson and his fraudulent signatures in the governor's race. This is well-established law that while if a Board of Canvassers refuses to act or conduct a recount or start it, then you can go to court and say, hey, you've got to start this investigation. But the discretion in how to do that, the statute has left that clearly to the discretion and has been time again and again and again reaffirmed. And it's frivolous and vexatious to bring us into court here today. As it relates to the audit or the fees, I wasn't involved in the initial briefing, but when I read it, I understood that there was a little bit of confusion about, well, somehow the court missed the citation about in Michigan law that is just clear black letter law, absentee voter boards are separate precincts for all purposes under the law and the statute. As a result of Proposal 2 in the constitutional amendment passed by voters in 2022, we now have early voting sites, which under the Constitution are to be treated the same as other precincts in the state. Now, we argue that that provision is self-executing and doesn't need additional implementing statute to be able to apply current and existing Michigan law at the time in 2023 to that. What happened in this case is the Secretary of State, in coordination with the county clerk, with coordination with the local clerk, all through contracts and service agreements approved by local city councils, approved by Board of Election Commissioners, did a pilot program of early voting sites in 2023. Now, what you have to get back to is what's the purpose of these costs and fees? There's a two-part purpose to it, and you can read it and we cite it in our brief, but there's two-part purpose to it. One is everybody who ever ran for anything and was unhappy with their election were filing for recounts, and it was costing our local clerks a lot of money. And so as a deterrent to filing frivolous or unwarranted recounts, the Michigan legislature said, we're going to impose a fee per precinct on recounts. So every time a clerk has to go and haul out a precinct box, hire workers to sit at the tables and do the inspections and count ballots, we're going to charge a fee so that people requesting a recount have a little bit of skin in the game. With early voting sites, and the Constitution requires them to be treated the same as election day precincts or AV board precincts, is the same. The clerk, when they're doing a recount, and I saw this in October of 24 or in December of 24 in Jackson, down in Jackson County, or Calhoun County, I'm sorry, in Calhoun County, you have to take these early voting sites and you have to separate. They're the most labor and time intensive precincts to count in a recount. And so that's why a fee is charged for those. It's required under the Constitution. That interpretation is backed up by the statute that was passed, Senate Bill 603 by the Senate last summer and becomes effective April 2nd. That interpretation and understanding is backed up by that implementing regulation. Therefore, we would request that the Court of Appeals reverse in part the trial court on the motion for reconsideration and reinstate the $2,000 fee for the early voting sites in the recount in December of 23. With that, I don't know if I have time left over. Hopefully I left my good friend and colleague, Mr. Richards, sufficient time as well. Thank you, unless you have questions.
Thank you.
How much more time do we have?
Probably 10 minutes. Yeah.
Thank you. So Gwendolyn Richards, I'm here on behalf of the City Clerk of Royal Oak, Melanie Hellas, in her official capacity. So we have heard from plaintiff everything that is backed up everything that we said in our brief on appeal. There has been no claim that's really lodged against my client that has any sufficiency here. Everything that the plaintiff has raised relates to Oakland County Board of Canvassers and not to the city clerk. Nothing that they're claiming is in her power or authority. All of this is addressed below. What is interesting, though, is that so legally the plaintiff does not deny this. There's nothing on appeal that indicates that they say otherwise. So while the trial court had decided in our favor and dismissed all claims against our client in a separate order from the Oakland County Board of Commissioners, it's only the appeal relates only to the Oakland County Board of Commissioners opinion and order that was issued the same day. And this is apparent when you look at the question on appeal, which relates specifically to granting the board's motion for summary disposition on the grounds. And the primary issue that the audit, incorrect word, was properly conducted pursuant to the Constitution and statutes, where the recount was a mere reiteration of running ballots through the unreliable machines and no investigation took place. There has been no disagreement here that the city clerk has absolutely no authority to run an investigation. The county clerk has no authority to determine what kind of machines or tabulators to use. That's determined at a different level. There's no disagreement whatsoever as to whether there's any relationship between the clerk and the fees, even though this isn't a part of the question. Those are all done at the county level. So it is clear under our Michigan case law that this is dispositive right here. We are done. Verrett versus Westinghouse, In re Indiana, Mettler Walloon versus Melrose, all stand for the proposition that an issue not contained in the statement of the question presented is deemed abandoned. So we are deeming this abandoned in our opinion. Likewise, even if the plaintiff had preserved some kind of claim, complete failure to develop both in their briefing and clearly in oral argument any claim against the city clerk necessitates the fact that this was the right decision by the trial court. We should be out of this case. And it's quite frankly vexatious to include us at this point. But even if this court were inclined to review the merits of plaintiff's claim, the circuit court correctly concluded that plaintiff was not entitled to relief. As we stated, Michigan election law assigns the role of conducting recounts and investigations to the county board and not the city clerk. This is clear under statutory law. MCL 168-869 states that upon the filing of a petition of recount, the giving of notice is given to the Board of County Canvassers, which shall be summoned by the clerk of the board and make an investigation. And 872, which is a big part of this debate, also relates to the investigatory powers of the Board of the County Canvassers, not the city clerk. The city clerk is not involved. I will also note that they talk about mootness here. And there has been a change. So they talk about mootness and claims that there's this issue of potentially, a chance of repetition and evading review, and therefore we should be looking at this even some more. That is not the case with this statute. An aside, 872 has been amended and it goes into effect in April 2025 before the next election. And that actually takes the investigatory powers from the Board of Canvassers and actually puts it to the prosecuting attorneys or attorney general. So the new amended statute states that if a Board of Canvassers conducting a recount has good reason to believe any fraud or violation of law has been committed in the canvass or return of votes, then that Board of Canvassers shall be, subject to Section 2, refer any matter the Board of Canvassers believes warrants investigation to the following. And it goes on to state that it should go to the prosecuting attorney or attorney general, depending on the situation. So even and still, if they're claiming that there's some sort of issue that could be repetitive, they're asking you to be making a decision on a statute that has no applicability in the next election. Just to put that out there. But Okay, so the circuit court correctly concluded that the plaintiff's complaint made clear that he sought an investigation at the Oakland County Board of Canvassers and not the city clerk, and failed to identify any recount-related duty on the part of the clerk. You can look at the complaint itself and all the exhibits. It is very clear that their
And the brief on appeal, there's nothing alleged.
Yes.
Yeah.
Exactly.
There's no duty alleged for your client.
Exactly. Exactly. So this has not been disputed. And really, this is, again, dispositive right here. Again, city clerk has no authority or a role in collecting the fees. And this is again indicated in the complaint itself when they submit a receipt that was sent to the Oakland County Board of Canvassers, or to Oakland County and not to my client. So once again, unrelated. As the circuit court concluded, the plaintiff did not seek any relief against the city clerk, respect to recount fees either. And they do not allege that they paid any fees to us. Finally, although plaintiff does not challenge a circuit court's dismissal of his claim relating to record preservation, any such challenge would fail on the merits, as the trial court rightly decided. They abandoned that actually at the trial court level as well, that we raised this in our brief and it was not addressed, but also it was all conjecture at the time. Not only is it moot because this is well past that election, it was in 2023, but nonetheless, it was the only support in the complaint were statements relating to like future events. So there was really nothing there that had any, I'm sorry, for past events. So it was relating to memos from the Secretary of State about past elections and preservation of records in that context, as well as a memo, a directive indicating that clerks should not be distributing election materials to outside people, completely unrelated to this issue. The one thing I will say too, and we addressed this in our earlier brief, some of this was the C8 motion. We were on the pleadings only, and so we're not going to address all the affidavits. But the point kind of relating to the one affidavit that was included, that was part of the petition for recount, really relates to a voter who had placed their absentee ballot in a mailbox. And as we all know, the U.S. Postal Service is very busy, depending on, particularly near an election, depending on how close your election, there is no guarantee that that ballot is going to make it to the city clerk's office on time. And we do not have a post office rule in the state unless you're an overseas or uniform voter. So the fact that a ballot may not make it to the city clerk's office is not fraud. And in actuality, there's transparency built into the process as part of Prop 2 enacted in 2022 that allows you to track your ballot. And when this case was filed, there was a tracker on Secretary of State's website, and you could track the status of your ballot. If your ballot had made it to the clerk's office, you would know from that tracker. You could also call the clerk's office and find out. So there's transparency built into this process already that continues to this day. And I think it's really important for taxpayers and voters to understand that this exists, and maybe some of this confusion can be avoided and help to not divert so many public resources to trying to explain what is really just the electoral process that we have right now. So with that, I would welcome any questions, but we do, for all these reasons, ask the court to affirm the circuit court's February 12th, 24 decision granting summary disposition for the city clerk.
Thank you very much. You have some time for rebuttal. I'm not sure on that. Probably a handful of minutes.
Thank you.
Yeah.
There are a number of matters that I want to respond to.
Can you start with the assertion that you didn't put the second issue in your questions presented?
Your Honor, I believe that it was discussed in the brief and in detail, the fee, and it is included in one question presented. It covers, so the question is phrased is, did the trial court err in granting the board's motion for summary disposition on mootness grounds that the primary issue was that an audit was properly conducted pursuant where the recount was a mere reiteration of running ballots through the machine. Mr. Harrison is contesting, as we have stated, that a recount did not occur, nor did an investigation. The court could remand it back and give him a full refund. He's contesting that it even took place in the first place. And, Mr. Harrison did not mislead the court with regards to his attachment with the Dominion root cause analysis of the EAC report. That is attached to demonstrate, and it was clear throughout this case that this jurisdiction used, and as I stated, Michigan uses 3 different vendors, ES&S, Hart, and Dominion. It was attached to show that it's not misinformation, that erroneous source code, when we have no transparency with machines, can cause an inaccurate tally. And we rely upon vendors in reporting results. And that's why the significance of a recount and investigation is so important. And it does not say that it's confirmed that this issue has been resolved throughout the country. In fact, the 5.5B system, and I don't want to go too far into Dominion, the patch was not utilized in a number of jurisdictions that then reported problems. So we rely again upon the vendor fixing something, and only that would be caught if a proper recount and investigation is done. And that would be one with transparency that reconciles every aspect of the election, where under 4165, the clerks maintain all records. And that would be the qualified voter roll. The voter roll is maintained in multiple places in Michigan. It's at the local level, it's through the driver database, it's stored on some of the tabulators where they could be remoted into. Experts have found the voter roll is in multiple places. So unless all of the data is reconciled and a full investigation takes place, these issues would not be caught, and that's why this matter is not moot. While the law has changed where the prosecutor and the police are recommended to be referred to with the Board of Canvassers in a recount if there's a problem, that could have still happened here. The Board of Canvassers could have and should have, based upon the affidavits that people were asserting that they voted and their vote was not counted, and they're not even reflected as having voted, that could have been referred, and the police could have assisted the Board of Canvassers in an investigation. But again, none of that happened. It was a non-transparent process where the same stack of papers were just shoved through the same machines. With regards to attachment F, again, they referred to misinformation, and there was a comment about 2020. In 2020, the Whitmer v. King case was filed in federal court, where it was promptly dismissed and called frivolous. There was a FOIA request in 2023 of all of the Detroit paper data that would have been discovered had discovery taken place in that case. In attachment F, it shows that there were up to 35,000 potentially fraudulent ballots, where the city of Detroit workers that were looking at the paper were saying the paper doesn't match. And there were more ballots than envelopes and more envelopes than ballots. So my point with this, in this attachment reflects, is that only a thorough investigation of the paper timely will reveal such issues. And that report is a really significant report because it was the expert that conducted that FOIA analysis is an expert that's been on retainer by the Secretary of State in the city of Detroit for 20 years. The FOIA utilized their own expert. But with that said, this was a non-transparent process. So Mr. Harrison is not saying that he gets to dictate how the investigation takes place. He's saying that the recount with the machine is an unconstitutional recount that's not transparent, and then diverts all control to the vendor to, again, electronically report results. And some type of investigation needs to take place, and it should have taken place here, and it did not. So for those reasons, he asked that.
Well, just for clarity, an investigation did take place, but it wasn't to the satisfaction of your client.
My client,
it's already been described that, and your client saw that an investigation took place with respect to individual ballots, the seals. There were steps taken to do an investigation by hand with eyes before even the machine-based recount.
I'm glad the court is asking about this. My client, first of all, they did not count 2 bags. They were not able to do a complete recount. That did not take place because if it's not properly sealed, it can't be recounted. So 2 bags were not counted. Secondly, none of that's sort of a show that goes through the motions that's not an actual investigation that would verify any.
But then this gets to the point you just made. You said your client's not allowed to dictate what the investigation would look like, but there was an investigation, but now you're saying it was just for show. It wasn't good enough, but we're bound by Barrow, which says, okay, yes, you have to be responsive. You have a clear legal duty to investigate, but it's not for the person who wants the investigation to dictate what it should look like.
My client disputes that an investigation was taken place. He agrees that there were steps taken to put the ballots through the machine again. So the bags were unsealed and a seal number was looked at. None of that reconciles the affidavits that were provided that reflect that people said they voted and it's not showing that they had voted. So what was in the bag is what needs to be investigated. That process would not determine that. So what he's saying is that the police could investigate the list of people that voted, how it's possible that people that under oath said that they voted and they're not on the list, right? What's in the bag? Just taking out the bag, just like if you're at the bank and putting it through the machine counter twice doesn't check it. It's actually verifying it by hand, looking at the paper in some respect. So while he's saying he doesn't need to dictate that entire process, there was no request for a police investigation. There was no further expert brought in on to look at the paper to make sure that these were all valid votes, and then to figure out where the missing votes were of why it was reflected and how that could possibly happen that people were reflected as not having voted, where they said under oath that that's what it said and they did vote. So that's what he's asking the court to consider, that this non-transparent process of a machine count is unconstitutional and reverse it back to the lower court. Thank you.
And Mr. Treblecock, I think you have a few minutes for rebuttal on the fees issue only, given that you're appellant in that case. You don't have to.
I'll just say, I guess a question for the court. On the fees issue, as we cast it, I think we've stated our piece on that. On the fees question, as I just heard it articulated by plaintiff appellee, I would have just a couple of quick rebuttals, if you indulge me for a minute. One is everything that I just heard screams discretion, 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 which this was a complaint for declaratory judgment and a complaint for mandamus. And where there's discretion, mandamus will not lie. I believe that's pretty darn close to a quote from countless Court of Appeals and Supreme Court decisions. So again, they may not like the process, but that is the statutory process we have in place and has been affirmed time and time and time again by this court. Second, I didn't see a count or a claim considered before, raised here, or raised in the complaint that somehow doing a facial challenge to the Michigan election law is unconstitutional. So that's the first I'm hearing that somehow there's a facial challenge to the constitutionality of the Michigan election law, because plaintiffs admit that a recount, that they took ballots out, they inspected them, and they reran them through the tabulators. They admit that Michigan election law allows that. They admit all these things. They just don't like it. They don't like the process. They want to see every single step.
And they said that their dissatisfaction with the process as it relates to the fees requires a full refund. Do you think that that by raising it in that way that they've satisfactorily preserved the issue with respect to fees?
No, I don't believe so, because the law says here's what a recount contains. They admit that that recount took place. Their dispute, and they didn't brief this at all, and to the extent they did, they were wrong, but I don't believe they briefed it at all or raised it, is that they didn't challenge the court's decision. If you read their appeal brief, they're challenging the court's original decision, that we then filed a motion for reconsider and the judge corrected it. If you say there were 3 buckets of fees on the original decision, the court went and granted Oakland County's fees for 2 of those buckets. They disagree with all of them, but they're only addressing the original decision, not the decision on motion for reconsideration. They don't address why the court got it wrong on the absentee ballot counting boards when there is specifically statute saying that absentee voter counting boards are precincts for all purposes under this act. That's not addressed at all. So I do believe that that fee argument is waived procedurally. And I'll just note, you know, their brief was 70 days late, then it got corrected 2 days later. The nature of this appeal and the clear statutory requirements that are just being ignored or glossed over, I think, is concerning, and what leads to more and more of this litigation. And so, again, we reiterate at our client's request that this does constitute a vexatious appeal, whether it's if you look at the fee issue, whether you look at the audit issue, and certainly, as you heard from my colleague, Ms. Richards, as it applies to the clerk. So, thank you.
Thank you. This case will be submitted.
Thank you.
Our final case for today and for this panel as a whole is a combined case number 22, docket numbers 371379 and 371380 in Ray Elkins Tri Minors. We have no parties endorsed for argument, so this case will be submitted on the briefs and considered on the briefs. It is deemed submitted. With that, we conclude our February 2025 case call with panel 2. Thank you very much.
Thank you.
Thank you.